Good evening. This is the City of Apache Junction's Board of Adjustment and Appeals meeting for the 7th day of October 2019. We are starting the meeting at 7 p.m. This time I'd ask you to all rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please.
Board Member Biggs.
Here.
Vice Chair Gage.
Here.
Board Member Walde.
Here.
Board Member Bucine.
Present.
Board Member Bory.
Here.
Chairman Shanebeck.
Here.
Six present, we have a quorum, Mr. Chairman.
Thank you. This time I would entertain a motion for the approval, the approval of the consent agenda. Braden, you have a couple issues?
I do, Mr. Chairman. Just a point of clarification on the agenda. It's my understanding it lists on the second page of the agenda that Mr. Mohadeen is represented by Aaron Ludwig of Ludwig Law Offices. It's my understanding that that's no longer the case, and that should probably be accurately reflected in the agenda. And then the other one is on the minutes. Let me get to it here. On the second page of the minutes, under the public hearing section, underneath Mr. Haloff, it states, Director Kirch read an email from Bill and Alicia Wallingford, which asked the board to vote on the issue during tonight's meeting. It was you, Chairman, that read that email.
Okay.
Those are the only two things.
What is the name of the lawyer tonight representing?
Well, the original applicant is Mr. Ludwig. So the original filing of the appeal was Attorney Aaron Ludwig. So all the public hearing notices were sent out that way. That's how it's been advertised since February 11th, I believe, was the first meeting. So that was the original applicant. That's who signed the appeal application form.
Thank you. At this time, I would entertain a motion with those two things in mind to approve the minutes and the agenda.
Mr. Chairman, I so move.
Do I have a second?
Second.
Roll call, please.
Vice Chair Gage.
Yes.
Board Member Biggs.
No.
Chairman Shanebeck.
Yes.
Board Member Bucine.
Yes.
Board Member Walde.
Yes.
Board Member Bory.
Yes.
So moved, Mr. Chairman.
Thank you. This time, I would entertain a motion for an executive session.
Mr. Chairman,
Yes.
I move that the Board of Adjustments convene into an executive session in the Development Services Conference Room for the purpose of discussion and consultation with the Board of Adjustments attorney for the purposes of legal advice regarding BA-1-18 in accordance with A.R.S. 38-431.03 and as further outlined on this agenda.
Have a second?
I second.
Roll call, please.
Board Member Bory.
Yes.
Vice Chair Gage.
Yes.
Chairman Shanebeck.
Yes.
Board Member Biggs.
Yes.
Board Member Walde.
Yes.
Board Member Bucine.
Yes.
So moved, Mr. Chairman.
Thank you. We will be adjourned briefly for an executive session. Okay, at this time, we'll reconvene our meeting of the Board of Adjustment, and we will now turn to the public hearing section of the agenda. Tonight, we have one advertised public hearing. Before we proceed, there are some ground rules. When called upon, please go to the speaker's podium, state your name and address for the record. Do not interrupt board members or those who are speaking. Common courtesy should be observed. This is going to be critical tonight, ladies and gentlemen. We need to keep civility in mind at all times. I know this is highly emotional for some people, but we need to keep a lid on the emotions and let us go through the procedure that we need to do tonight. No personal attacks shall be made. Please address me as Chairman Shanebeck and any members as board members. This is a public hearing, which means the public can observe and speak on this matter. Each member of the public may speak for 5 minutes when the matter is open for public input. If there are attorneys who represent either side, they will be represented. They will be recognized. They are here. And this is how this hearing will proceed generally. Because the burden of proof under state law is the applicant's, and the city's position is presumed valid absent evidence to the contrary, the applicant will present its case first. Staff will then present the city's side. Both sides can ask questions to one another and can present evidence that the board can consider, including witnesses and whatever is submitted in the packet. The public will then be given a chance to speak with a 5-minute time limit. The public session will then be closed. The board will discuss the case in public and can recall the applicant and staff should they have any questions. The board can also reopen the matter to public comment if it chooses to do so. The chairperson will ask for a motion and any second. The board has the option to continue, to side with the applicant, to side with staff, and to modify the staff's earlier determinations. So let's proceed. First public hearing tonight is entitled BA 1-18. All witnesses, please rise and raise your right hand and affirm the following. Anybody who plans to testify tonight? Okay. Let me get here. I do solemnly swear that I will state the truth, the whole truth, and nothing but the truth, so help me God.
I will.
Thank you. Applicant, please present your case.
Good evening, members of the board. Chairman Shanebeck, thank you for having us here.
I got it. Let me drive.
Can you, okay, I'll let you drive, thank you.
Your name and address, please.
My name is Devon Veeder. I represent Mo, Mr. Muhyiddin. We're gonna call him Mo tonight, that's what he goes by. I'm just going to cover the first portion of this presentation tonight, which is actually kind of the fun portion. I'm gonna talk about the hitching post and Mo and some of the contributions that he makes to this community and to Apache Junction. What I'm going to do is just go through a few of the highlights of the many, many letters and emails that we've received from the community attesting to Mo and the hitching post and the contributions that he has made to the community and to Apache Junction. So I'll just jump into it here. The first one here is from Arizona State Legislature Representative John Fillmore. He said in a lengthier letter, which explained more, but this is just a highlight. Mr. Muhyiddin has been an exemplary community supporter, and his establishment a point of pride for Apache Junction. Next one here is from Todd House, District 5 Pinal County Supervisor. I'm not going to read that whole thing, but let me just get to the end here. He says, last but not least, Mr. Muhyiddin brings tourism and money into the community, as well as raises money for first responders. Mo has been very active in helping first responders in their cause. Another couple here from the Apache Junction Unified School District. The hitching post has been supportive of Apache Junction Unified School District's athletics programs by hosting dinners as well as donating backpacks for elementary school students. Also from the Black and Gold Youth Football Board of Directors, you can see that Mo and the hitching post has been very good about supporting their organization. This is my favorite slide from the night. Stacy Rakewald, I might have said that wrong. She said, I love that our community has the hitching post and the bull riding. It has provided such a positive learning environment for so many youth riders. Now, Stacy is the mother of Logan, who I believe is the Arizona State champion bull rider, who's competing professionally now. Now, this picture, I think that if you look through some of my family albums, you would see a picture just like this of me at that age trying to ride a sheep, but it was actually at Lehigh Days where I grew up my first few years. They have something called Lehigh Days, and in fact, they still do it. I just was there last year, last year's Lehigh Days, and I can remember my dad forcing me onto a sheep, and I probably had the same face that this young man has right here, trying my best to hold on to the sheep, which I never did very well. But Had the hitching post and Mo been around back then, maybe I could have had some training and gone to the hitching post once a year and practiced riding some sheep like is available now once a week, actually. So another quote here from the Coates. You can see that that the hitching post donated for the first responders of the Woodbury fire. Andrew Tryon from the Superstition firefighters. Mo sacrificed profit to give back to his community and those of us that help protect it, and he puts his own time and effort into making the eventful successful. And as you can see here, Mo's contributions, these are outside of those ones that we just cited there, that he's contributed quite a bit to the community and to the Apache Junction. That's all I have for this short portion here. I'm going to turn the time over now to Stephen Brower to cover the rest of the presentation.
Thank you, and good evening, members of the board. It's nice to be here. Thank you.
Would you state your name and address?
Steve Brower with Brentwood Law Group. I'm representing Mr. Mo. So, to start off, if my PowerPoint skills don't fail me, I want to start off about what is our limited focus for the Board of Adjustments hearing, and that limited focus is this statement of violations, which are found in 2 different violations. The statement of violations says very simply, and we can see this in both notices of violation, that parking on parcel 125-043C is not permitted by the Economic Development Agreement. Now, that's the key language. If I receive a citation, if I get pulled over, and I get pulled over for a tail light being out, for instance, but actually my tail light's not out, it's a proof of insurance issue, or I was speeding, etc., the citation is not the correct citation. This citation, parking on parcel 125-043C, what we would ask respectfully is make the determination whether parking on this parcel is permitted or prohibited by the Economic Development Agreement. What is this parcel? This parcel, as you can see in the middle of your screen here, is the entire parcel, which here's an aerial photograph of that area. It spans that entire northern area. It includes the Hitching Post Saloon. It includes the parking out in front of the restaurant. It includes the arena. It includes the parking to the south of the arena, and it includes that entire parcel. I ask you, board members, is parking prohibited on this parcel by the Economic Development Agreement? If the answer is no, then the violation itself is not correct. And that is kind of the end of this hearing. Here's the zoom out view, which we're going to come back to a couple times, of the hitching post and what is around the hitching post. To the north, for instance, we see that there's the Elks Lodge, and that becomes important. And that you can see some parking of some vehicles and some boats to the south of the arena there, and to the south of the Elks Lodge, which I will come back to. What we have here is we've got side by side. Here is the, I guess, the parcel viewer versus the what would you call that? The satellite image of the property. I couldn't think of the word for some reason for a moment. Side by side, so you can see how the property is currently assembled. Now, the question is there no parking anywhere on that entire property? See the question mark. That's not a foregone conclusion. That is your decision to be made. The question really is not one for interpretation of the zoning code, which is a little unusual, being in front of the Board of Adjustments, saying that we're not here to interpret the zoning code. We're here to discuss a contract. An economic development agreement, as you well know, Did I push 3? I'm gonna try this. He said that if I push 3, then the 4 on here, okay. Okay. I can't work the remote at home either. I need my kids for that. Okay. That's the honest truth. Okay, so economic development agreements, and this comes from the Apache Junction City Code. We've got intent and purpose, the applicability, administrative responsibilities, legal reviews, city council approval required, et cetera. What is a development agreement? It is a contract. That is the exact wording of the Apache Junction City Code. Right next to the intent and purpose, 1-16-13A, intent and purpose. And a development agreement is a contract. Okay, the last sentence of that. The agreement can also facilitate enforcement of requirements since it is a contract that details the obligations of the developer and city. Now, what is a development agreement purposed for? Well, if you'd be so kind as to allow me to read a little bit more, a development agreement is a contract between a local jurisdiction and a person who has an ownership or control of property within the jurisdiction. The purpose of the agreement is to specify the standards and conditions that will govern development of the property, and the development agreement provides assurance to the developer that she may proceed to develop the project subject to the rules and regulations in effect at the time of the approval, and that the development will not be subject to subsequent changes and regulations. So a development agreement is to protect the developer and to specify requirements, of course, and it is a contract. What if there's a difference of opinion of the interpretation of a contract? You sue. You go to Superior Court and you make your argument to Superior Court why you believe the contract says something else. What if the City of Apache Junction enters into a contract with someone to supply staples or paper clips, and that person doesn't show up to supply the City of Apache Junction or the contract? The City of Apache Junction sues under that contract, sues in Superior Court. The City of Apache Junction doesn't act as jury and judge to enforce its own contract when it's a contract between the city as party and a private individual and developer. This is different than interpreting the zoning code. With the zoning code, the Board of Adjustments does interpret, of course, the nuances of the law and whether it should be applied a certain way in one case or another. In purposes of contract interpretation, that is something for the Superior Court judge to do. And we bring that out in advance just to preserve the objection to the jurisdiction and our objection that the Superior Court is the arbiter, or actually the decider of contracts. Now, the Board of Adjustments can be an administrator, of course. Under administrative responsibilities, development agreements, whether they are administered by the Development Services Department Planning Division or the actual Economic Development Division, really depends on how much economic incentives are in the development agreement. And I leave that to the good people that wrote this law to determine who administers what in which instance. In your instance, it appears as though that this has been brought in front of you as a person to make a decision on whether to administer, to go forward on this. But we would submit not as a decider of the interpretation of the development agreement. Now, what does the development agreement do? Does the development agreement, going back to, how do I go back now to, I'm going to push 1 on accident, and now I'll push 3. Okay. Going back to the development agreement at issue, Does the development agreement, as stated in the notice of violation and the citation citing Mo for breaking the law, does it really prohibit or not permit any parking anywhere on the land, this entire parcel? We would respectfully submit that that's just not the case, and that this hearing should be decided on that basis alone. And many other reasons which go in favor of our client, Mr. Mo. Here is, now, what you'll hear today from others is that the third development agreement is the operative development agreement. It is. So, in other words, there's been the original development agreement, and then there was the First Amendment, and then the Second Amendment, and then the Third Amendment to the development agreement. Now, what does the Third Amendment to the Development Agreement actually amend? We see in Section E of that all of the other terms and provisions set forth in the agreement, meaning the original agreement, the First Amendment, and the Second Amendment, not inconsistent with the Third Amendment, remain in full force and effect. So, this incorporates in the provisions of the Second Development Agreement, not inconsistent. Let's go to the Second Amended Development Agreement. This section from Section B of the Second Amendment to the Development Agreement talks about the outdoor bull riding arena. The outdoor bull riding arena is conditioned upon shared parking agreements for overflow, off-site parking on vacant property to the south, or across Lost Dutchman Boulevard to the north at the Elks Club. Now, you're going to hear a lot about the site plans and the site plans attached to the Second Amendment to the Development Agreement and the Third Amendment to the Development Agreement, and the fact that parking is not designated on the site plans in a certain way. Okay, where is there's a site plan attached to this Second Amendment to the Development Agreement. And this site plan attached to the Second Amended Development Agreement does not show off-site parking. Why? Because it's a site plan. It's not an off-site plan. The off-site parking, see, this property that Mo did not own until later, and I'll tell you why he bought it, to assure that he would always have parking in this area that he was supposed to have parking in, which was smart of him, and he shouldn't be punished for that. It was not owned by Mo at the time that it was that the Second and the Third Amended to the Development Agreement was entered. So you have, for instance, if the argument that all parking needed to be on the site plan was truly correct, well, then you would see parking designated on the Elks Club area. Let's go back. Okay, here we go. See, the Elks Club is north of the hitching post, and that dirt lot north is used as parking. You would see on the site plan the parking at the Elks Club. You would also see parking designated on the site plan the south of the Elks Club. After all, parking needed to be either to the north or to the south. It needed to be in the Elks Club Lodge area, or it needed to be across the street south of that to the to that area south of the arena across the street from Elks Lodge. Neither of those are depicted on the site plan because it was off-site parking. This is the crux of why we're here. Whether Mo's business can continue to use this, what used to be off-site parking, for parking needed for the arena, as contemplated by the Second Amendment to the Development Agreement, incorporated into the Third Amendment to the Development Agreement. Here's where the arena was developed. This is a Google Maps shot. It shows that the arena kind of shows the contours of where the arena has started to be developed, and it shows the area to the south of that arena. I'm going to show you now, this is attached to the Second Amendment to the Development Agreement, and although it shows some parking on site, it has this this discussion here about this area that is off-site. And that, as I mentioned just a moment ago, you do not see on this site plan anywhere. It's not found in the window of the opportunity of where the parking would go, the Elks Lodge, anywhere. You do not see, and the reason for that is because it wasn't intended to be designated on the site plan. The site plan was not intended to designate and restrict parking only to the area shown on the site plan. Else, you could not interpret Section B of the Second Amendment to the Development Agreement as making any sense at all, which section refers to the Elks Lodge area, which is not depicted on the site plan, and the area to the south, which is referenced here as APN 125-001C, Zoning General Commercial Owner Zion International LLC, Use Parking and Storage Yard. Now, you'll also perhaps hear some arguments about, well, was that area really used or usable for parking? Let me just submit to you right now, that's not why we're here. We're here to look at the narrow issue of whether the violation issued, and that violation being very narrow, is there no parking permitted? Is all parking prohibited on the site, on the entire property? That's why we're here. However, because it will be brought up, we see clearly from this reference, the site plan that was adopted into the Second Amended Development Agreement, that there was a recognition of the use of that property for parking already at the time that the Second Amendment to the Development Agreement was signed, recorded, agreed to, enacted, all those things. The one thing I really forgot was some bottled water. I feel myself getting a little cotton mouth. Thank you so much, sir. I appreciate that. Let me submit to you that this case for Mr. Moe is so much worse than getting a parking ticket. But let me use that as an analogy for a moment. After all, we are talking about a violation that is claiming that Mr. Moe broke the law, okay? So when someone receives a parking ticket, the no parking zone has to be clearly defined. If you receive a no parking ticket in the middle of the day without a no parking zone clearly defined, what's your defense? Your defense to the court is there was no designation here. The law has to be clear. If you're going to potentially put me in jail, if you're going to fine me, you're going to give me some criminal consequence, then you need to make the law clear. The burden is on the city or the state or the federal government who is imposing the criminal issue on me. The tie goes to the runner. If there is ambiguity, you should not hold someone to have broken the law in the case of ambiguity. Here, there's no ambiguity that parking should be either to the north, to the Elks Club, or to the south in that area that you see the highlighting there. There's no ambiguity either, and you will not hear anyone state and cite to line and verse anywhere in any economic development agreement that prohibits parking, that says this is a no parking zone, because it does not exist. The language that you'll hear that is cited to says that the property must be built out and the project must be developed in accordance with the site plan. There's no argument that Mr. Moe did not build out or develop the project in accordance with the site plan. You'll also hear that he did not even own the off-site areas, as I've stated before, at the time of the Second and the third amendment to the development agreement, which is why those areas would not even be subject to the site plan. But yet, because parking was allowed in those areas, it is continued. And parking has been continuous in that area, which is the closest area to the arena since the 2014 development, at the time of that development. What we, beside the simplicity of this case and the fact that on one hand, the question is really limited to whether the violation that Mr. Moe was cited with, saying that he broke the law, should be upheld, which we respectfully submit should not be. And beside the fact that the second and third amendment to the development agreement do contemplate parking in areas outside of the site plan, i.e. off-site parking areas, the other issues about what was the zoning of the area to the south at the time that the new zoning code was enacted, and whether parking and storage are the same, or what does it mean to store a vehicle in an area, how long a vehicle has to be stored for it to be considered stored, et cetera, is all kind of a matter of, it's an interesting academic exercise, maybe interesting. I find it interesting. It's not relevant. The case is much simpler than that. And number two, it is not something to find someone's business to be shut down over if it came to that. It is not ripe, and it is not truly before the board as of this time. And with that, I would like to save further comments for my closings. Unless you have questions, I apologize.
Start at the end. Luciano, any questions?
No question.
Braden?
You always start down here.
Well, you don't have to go first.
No, that's fine. It's Mr. Brower, correct?
Yes,
Okay.
thank you, Mr. Biggs.
So can you go back to the slide, if possible, on that you showed the entire property?
Yes, I sure can. Let's go back to, here's the entire property as well as the property to the north, or would you like me to?
No, that's fine. So everything that you're saying is part of the hitching post property or parcel 100-25-043C. You're saying that there is, the way you were interpreting it, is that there is no parking anywhere on that property at all, even in the front along Highway 88.
Right. So the notice of violation says, and I have that notice of violation with me, but it says simply put that violation observed, a violation of the Economic Development Agreement constitutes a violation of Article 1-16, Section 116-13. And then, if I could, I will just quickly push 3? 3, everyone? Okay. 3. Let's see. 4. Okay, 4. And with 4, for me to push that, I have to push the right number. Here we have. Okay, so here's the, before the corrective actions to be taken, parking on parcel 125-43C is not permitted by the Economic Development Agreement. Is that correct? It's not correct. That violation itself is like me getting a ticket for my tail light being out when I don't have a tail light out. That is not a correct statement, and no one should be found to have broke the law in appealing a violation that is just patently not correct.
So these two violations occurred on October 31st of 2018 and November 7th of 2018.
Yes.
So at which point in time in these three economic development agreements, the first one being in February of 2009, the second one being in October of 2013, and the third being in October of 2014, did these parcels, it is my understanding that these were 4 or 5 separate parcels that then all became one, with the exception of the lot to the south, which is the house.
I think that there was something like that going on. Yes, thank you.
So when did these parcels become one parcel? Because you've also stated that the parking or storage, which is originally 001C, was not a part of the site plan due to the fact that it was off-site and not owned by that property. So at which point did these all merge and become one property where
Yes.
you feel that now it's a part of the economic development agreement, and which economic development agreement should this originally have been placed under?
So the last thing you said is the most complicated, but let me start by answering the question. The assemblage of the parcels occurred July 6th, 2014. So after the third amendment to the development agreement had been enacted and recorded. The third amendment to the economic development agreement, which was enacted before the assemblage, did allow the bull riding on the property that Mr. Moe owned at the time, along with off-site parking in the area that was to the north at Elks Lodge, or to the south in this property that Mr. Moe quickly bought, so there would never be a violation of any sort of economic development agreement. Because the problem with the economic development agreement, or the worry being that if it's dependent upon off-site parking in these two areas, what if both landlords just refuse to deal with Moe at some point? Will his operation cease? So Mr. Moe was smart and acquired the property to make sure that that never would occur, and that occurred, and he acquired it after the third amendment to the development agreement was enacted and recorded.
Which I believe that was a stipulation in the second or third economic development agreement, that parking had to be at one of the two off-sites with that agreement.
Yes,
So,
correct.
so then at that point, Mr. Mohideen purchased from Zion, I assume?
Yes,
Okay.
from Zion,
From,
yes.
purchased that lot from Zion, and the third economic development agreement was already done, because that was done on June 17th.
Yes,
And
correct.
the third, or that lot was purchased when?
July 6th,
July 6th,
2014.
okay.
Yes.
So a month after, essentially.
Yes.
And
He acted quickly.
that, you believe, would be grandfathered then under the parking for the other lot, because he now has sufficient parking in this acquired lot.
It was contemplated, yes, exactly, that it would that parking would either be at Elks Lodge or in this area that Mr. Moe acquired.
But at the time, they were separate parcels.
Yes, yes.
So, okay.
And now whether the parking and as we saw on that slide that we looked at a moment ago, at the time of the economic development, the amendment to the economic development agreement was enacted, that area was designated and shown as the use was parking and storage. Whether that qualifies as grandfathering for purposes of changes to the zoning code in 2014 is beyond the scope of the Board of Adjustments hearing, because your sole issue is, did Mr. Moe break the law by violating the economic development agreement? This, this issue outside of the economic development agreement is a different issue, not something that Mr. Moe has been cited with, not something that we're here to appeal yet, if he ever is cited with that. There would need to be a different citation, of course. Just like with my tail light being out, when I was speeding or something to that effect, the citation that we're here appealing, in fairness, is the citation that Mr. Moe was provided with.
But you're stating that the citation is for parking on parcel 043C, which is now the entire property and consisted of 5 separate parcels now merged into one.
Yes.
However, the lot in question, even though these are now all one parcels, at the time of the economic development agreement, they were separate parcels. So we have to take into account the fact that they were separate parcels at the time of the economic development agreement, regardless of what it is today. We have to look at 5 years ago, back in 2014, when this third economic development agreement was signed and agreed upon, that they were 5 separate parcels.
Oh, certainly.
So
Yeah, certainly.
So-
And this parcel right here did not exist.
Correct.
And never did exist. So to say that the economic development agreement prohibits parking on a parcel that didn't ever even exist at the time is kind of it's an impossibility. There's nothing in the economic development agreement that could have even spelled that out because the parcel didn't exist at the time.
Correct, but you're arguing that parcel 001C, which was the original parcel, the original parking and storage lot, it satisfied the requirement of off-site parking.
Yes.
If the lot across the street, being the Elks Lodge, or their additional parking was not available, that the separate parcel at the time of June of 2014 satisfies the requirement for off-site parking because it was leased by a Zion International, by Mr. Mohadeen under a different corporation or LLC or whomever, that lot satisfies the parking requirement under the second and third economic development agreement.
If that was what the violation was that we were in front of today, I would argue that. I would absolutely argue that if that was what the violation was that we were here discussing today. I would say that that parking, off-site parking, would have needed to be satisfied either through the Elks Lodge parking or to the south across the street from the Elks Lodge parking to the south in that Zion's lot that Mr. Moe purchased. Yes.
You good, Braden?
No, not at this time, thank you.
Mulder?
Yes, first of all, does anyone have a pen? Mine died. I'll give it back. Thank you. Okay, yeah, my questions ran similar along what Braden's did. But mine in your section B of the Second Amendment requires parking to the south of the rodeo arena. Now, it states that it has to be, across Los Angeles Boulevard to the north of the Elks Club, or should be south of the bull riding arena. Now, was this something that Moe had already discussed previously with the Elks Lodge or the tenants, or was this something that he was, rolling the dice and hoping that they would let him park there, and then developing it? Or was this something that he had in mind to buy this property to specifically use it for parking upon that agreement? Because the timeline, I'm going to agree with Braden, is like, it's they come up with the agreement and then a month after it, all of a sudden becomes a different parcel, which complicates the issue in my mind a little bit.
Sure. Well, and remember yes, so I cannot answer that question, but I do have Mr. Moe here, and he's sworn in, and he could answer that question, and I'd love for him to do so. But remember that parking agreement was actually in the Second Amendment to the Development Agreement, which was then also incorporated into the Third Amendment to the Development Agreement. So the closeness in time between the Third Amendment to the Development Agreement and his purchase ignores the fact that the second amendment to the development agreement had already been put in place. Help me out here, 2 years prior,
Yeah,
perhaps?
that's what I was trying to get the timeline all straight in
Yes.
my head, because it's a
Yes.
big packet. I've read through it a couple times, but the dates get confusing a little bit.
Yeah, I don't have
So
the-
the second agreement was 2 years before, 2009 or 2012?
Well,
13.
yeah, 2013, so almost 2 years, but it was 2013, and then the 2014 was the third amendment to the development agreement.
Now, I'm sorry, you're gonna have to refresh my memory again. In that third agreement, was there anything specifically hammered out about parking, or was it just assumed that it was taken care of in that second agreement?
It's,
Right, yeah, I've read that.
Yeah.
But in the third agreement, was there anything specifically mentioned about parking, or was it just
No.
grandfathered in that it would be, under the second agreement, would satisfy the needs of the parking for the new arena?
There was nothing discussed about parking in the third amendment to the development agreement, other than that there was, of course, incorporation into the third amendment to the development agreement, anything from before. Now, the reason for the parking in the second amendment to the development agreement is there's an arena. There's
Yeah,
going to
it-
need to be
it increases
patrons.
traffic too.
Right,
Yeah,
exactly.
That makes sense to me,
Yes.
but I'm just trying to make sure that I got all the dates straight in my head, because it is important. And I'm not saying that that's going to sway my decision one way or another, whether it was Mo's intention to buy that parking lot or not, but I'm just trying to make sure that I understand the timeline here. Yeah.
Mahmood Mayuddin, 2304 North Cortez Road, Apache Junction, Arizona. Owner of the. Okay, I'm sorry. Mahmood Mayuddin, 2304 North Cortez Road, Apache Junction, Arizona. In the picture that you see, that's the house, and the swimming pool you see, that's a house.
Yeah.
Okay, this parcel we are talking about, 143C, I don't exactly remember the parcel number, but ending up with the C.
Yeah.
If you guys go back before they changed the zones, used to be called the CB2. Right now, the City of Apache Junction rezoned that area, gave a name B1 and B2. They're all Business 1, Business 2, that's the zone. If you go back last 20 years, that parcel is this. Yeah.
I did hit 4, but it's not a minute.
You have to push it a couple times. There we go.
Okay. That is south of the Elks Lodge. That's a parcel that we are talking about. This parcel is come through that gate and then come down this way and turn this way, all the way come to that was Highway 88. And there was, in the very small corner, there was a small triangle parcel was existing. That parcel was not on the list. That parcel number was not on the lease agreement or anything on it. That was a parcel was leased from Zion International. That was a parcel east of the bull riding arena, wrap around along with this way to the gate, and then cover this whole area. There's a south of the hitching post also. That area was leased from the Zion International. Leased from Zion International for off-site parking because they're owned by the Zion International.
Yeah, okay.
We started the bull riding in November 2014. When you look at the third development agreement, is referred back to the second development agreement. Does not specify any parcel number or anything on that one. And this was the only dividing line that was showing in that development agreement. The Lost Dutchman is a dividing line. North of Lost Dutchman is a Elks Lodge. You see that is a dirt lot over there. That was the dirt lot that was leased to the hitching post.
Yes.
And after that, south of that Lost Dutchman, that parcel, exactly 143C, that was from Zion International, that was leased from them. We purchased that property in July 12 or July 14. You guys should have in a package, or my attorney submitted that. Bull riding was not even started.
Yeah.
We purchased that property to make sure we have enough parking. When we purchased the entire property, then we clean up this area, remove all the boats and all that stuff in a secure area, and then make more economical people and easy to fit on that location, how many cars we can fit in. That was the original problem, was we used that area for parking. Only reason that area was used for parking, when we built the bull riding arena, planning and development came over there, check it out, how many car we can park in that. That's what then they allow, that is right over here, the hitching post, coming to that parking area, there was a gate. They ask us to install the gate so people can go in and out, and they make that gate as emergency exit.
And let me just add, thank you, Mo, I appreciate that. Let me just add that installation of a fence or a gate is not considered a structure for purposes of redevelopment or development under the zoning code, as you know. And that is what Mr. Mo said was how things developed there. I want to bring up one other just analogy. The analogy being, if I come, and I know it's not the exact same, okay, but if I come and I want to build a new house, and I go through the process and I'm getting the plans approved and things like that, and the city says, yes, go ahead, move forward with your construction, and I do everything to code. You know, you build out the property exactly as I'm supposed to, and I develop out the property exactly as I'm supposed to. Now, can I park on the street? You know, in other words, the approvals don't restrict my ability to do things that I can do otherwise. And if the economic development agreement here, which we believe does actually provide for parking either at the Elks Lodge or to the south, but even if it were ambiguous, there's no prohibition in the economic development agreement. And the violation that we're here to discuss right now is does the economic development agreement act as a prohibition so that Mr. Mo has broken the law? And that's just not the case from our humble perspective. And we would respectfully submit to you that is where it comes out to.
Good. Yeah, I'm satisfied, yep.
Judy?
I was just looking at the plan, and I was wondering, what was the zoning on those 5 parcels?
Okay, so the area, oh, I can use my mouse. This area that shows the parking and the storage, that was a CB3. CB3. And the rest of the land was CB2.
Which means what?
Sorry, commercial. It's my understanding under the old zoning code, which was being changed right around the same time as all this was occurring, CB3 was a different commercial zoning that incorporated in all the uses of CB2, which incorporated in all the uses of CB1. And so it kind of just, as you got from CB1 to CB2 to CB3 to CB4, it got more and more inclusive. So CB3 included more permitted use than even did CB2.
Parking use?
Yeah, the parking that's on there, yes, absolutely. Yes. I wish that no parking sign wasn't there. You could see vehicles parked on that vacant lot even in 2014 when that Google Maps. It must have been 2014 because you can see the arena's already started to be constructed at that time. Maybe I can find a better version of that.
So then when it went from 5 parcels to 1 parcel or 3 parcels to
Yeah.
1 parcel, what was the zoning then?
The zoning had been changed by the city by then, so it was no longer the CB type of zones. It was B2 at that point. So, it went from CB3 and CB2, depending on where on the land you're talking, into an assemblage into a B2 zone. a business use too, I guess.
Okay. Jesse?
So just that I understand, right now, the property that Mo owns is all included in the one parcel number 100-25-043C.
Yes, that's
And
correct.
that was 5 parcels that were combined,
I
4 or 5?
I know there were parcels combined. I'm going to say 4 or 5. I think it may have been 3, though.
4?
Oh, 4, okay, thank you.
Any other questions, board? All right, thank you, sir. Staff, please present your case.
Mr. Chair,
Yes.
if I may. Good evening, Board. Joel Stern for the City of Apache Junction. Today, we're going to have Larry do most of the presentation. I will comment, if I'm allowed to, later on certain items. And I do want to respond to some of Mr. Brower's arguments. So Mr. Larry Kirch will now speak on behalf of the city.
Thank you.
Good evening, Chairman Shanebeck. Excuse me, that's why I need the water. I'm getting over a cold. Commissioners, also Rudy Esquivius, Planning Manager, will also be coming in at the appropriate time as well. So tonight we're going to talk about the Board of Adjustment case, BA 1-18. We do have a big packet. I appreciate everybody's indulgence in going through all that, perhaps more than once. Excuse me. Tonight I'm going to give an overview of case BA 118. I'm going to review Mr. Ludwig's appeal, and his appeal relates to Exhibits 1 through 9 in the packet. In addition, staff put together a supplementary staff memorandum as it relates to a subsequent submittal on May 13th by Mr. McKee. And so those exhibits relate to 10 through 20, except I believe 17 and 18, which were the citizen submittals. And then we do have a staff recommendation, and of course you also have a public hearing tonight. The appeal filed by Attorney Ludwig was filed on December 3rd. In that, and you have that in your packet. That is Exhibit 1. So the hearing was originally set, I'm just kind of going through some background right now. It was originally set for February 11th. Prior to February 11th, the applicant requested a continuance to May 13th. Prior to May 13th, the applicant requested a continuance to July 8th. And just prior to, I think it was July 1st, the applicant requested a continuance to this evening. So in order to have the hearing tonight, as you know, a sign was posted at the site. Notices were sent out to property owners within 300 feet, and we put a legal ad in the newspaper. That ad was advertising the February meeting, so it's been continued since then. Again, your packet includes all the correspondence we've received from neighboring property owners, as well as the one item that was discussed at the couple items that were presented at previous meetings. So there are 2 notices of violation that we're here to talk about tonight. Again, the zoning administrator's determination whether an economic development agreement and its amendments allows for parking in areas outside the site plan, Exhibit A. So we'll walk through that again. I know we just went through it, and I apologize, but we're going to unfortunately go through it again. To me, the case really boils down to the validity of an economic development agreement that's prepared pursuant to the zoning code and state statutes, and whether both the city and developer have obligations that are spelled out in those development agreements. And so, again, we'll hear more about those obligations that are set forth in there, primarily the site plan, of course. And then I also wanted to point out that we really now have 3 different submittals with different arguments being made. So Mr. Ludwig submitted an appeal in December of 2018, And then at the hearing on May 13th, there was a packet handed out. That meeting was continued, and so we were set for July, so staff prepared a memorandum dealing with a whole new set of items that were being stated as for rationale for the appeal. And again, last Wednesday at 4:27, we received the packet that you have been emailed to you again today that covers Mr. Brower's comments. So in order to try to simplify this, because it is not that simple, Mr. Ludwig had two arguments that he presented, in that it was a permitted use by right, or that it was permitted by the Economic Development Agreement and its amendments and key phrase, site plans. Mr. McKee, who apparently didn't represent Mr. Mohadeen, but he emailed the packet to me that day on May 13th. It was handed out at the meeting. Mr. McKee put together four arguments as to why the zoning administrator's determination should be not withheld, if you will. Again, he argued that it was a permitted use by right, that parking to the east of the hitching post property was either allowed by right, or perhaps it was grandfathered, or that it was allowed to the east, and perhaps, again, the contrary to that is if it's not prohibited, therefore it's permitted. So we'll get into the zoning code. We'll get into the zoning code that was in effect prior to 2014, as well as the zoning code afterwards. Mr. Brower with Brentwood Law Group has a different argument that, to me, the argument that we should be talking about is Mr. Ludwig, the original appeal. And so for the board's perspective, having different arguments presented over the course of 6 months or 8 months has not been easy. So again, you've heard from Mr. Brower. His arguments relate to the parcel 43C, and that, near as I can tell, is that the property to the east, which was also Zion International Park and Save, is that area to the east that Mr. McKee calls to the east is now being called to the south. So again, perhaps that's adding to some confusion. So Mr. Ludwig, in their application dated December 3rd, said that the appellant's use of the parcel as a full-service restaurant, drinking place with adequate off-street parking are uses permitted both by right and by the Economic Development Agreement, its amendments and site plans. And so there's 3 questions in that application. So the third question asks the applicant to describe your interpretation of the section numbers listed above, and I'll get to those in a minute, and provide any other reasoning to support your appeal. So the support for the appeal was that our zoning administrator determination is because the city attorney was arbitrary and capricious. That's what that says. So the rationale for our defective zoning interpretation as a Board of Appeals is on this argument that there is no narrative that goes with this application. There's the application form, there's the addresses of the neighbors within 300 feet. There is nothing other than the first page that explains what Mr. Ludwig was getting at with regard to his appeal. So there's no reference to what the illegal CUP is or anything else. So these are the section numbers that Mr. Ludwig identified in the first question. Was provide the zoning ordinance section numbers which you believe were incorrectly interpreted by the zoning administrator. So those are the sections that Mr. Ludwig cited, but at the same time, again, provided no narrative as to where the zoning administrator went wrong. Just that these are the sections. So we're left to try to interpret someone who's not even here anymore what their original application was all about. So again, it's been noted that the burden of proof is on the applicant. There is no substantiation from Mr. Ludwig as to the fine narrative that the new attorneys have provided. There is a narrative. You can try to get something out of it. But Mr. Ludwig, the original appeal, there is no substantiation to any of that. Those are all outlined in the staff report. So one by one, in the staff report, I go through each of those arguments. I can do it again tonight if you like, but it would take a lot more time. in fact, two of those sections don't even exist. So Section 1-2 and Section 1-7 are not even sections of the zoning code. So I think in some respect that the application is somewhat defective. So let's into the history of the development agreement. So the very first development agreement was put together because Mr. Mohideen had acquired some property and wanted to do development in the city. And the city, in effect, waived development fees in the amount of $46,488. So again, we get to the obligations of the city and the developer. In the first original development agreement, that was, you're going to do a project, the city will waive these fees. There was the First Amendment, which related to helping Mr. Mohideen through some financial difficulties in terms of providing for landscaping, and the entryways were supposed to be defined in the development where you could pull in for parking. So the city did the First Amendment to allow those accommodations to allow Mr. Mohideen to proceed, but with some extended deadlines. The Second Amendment occurred. The bull riding arena actually started before the Second Amendment. So the purpose of the Second Amendment was to now accommodate a development that had already started. So I will go to the development agreement language that in the exhibit that you have, the development agreements are all in here. So this is the very first development agreement. Again, it explains the development agreement and the developer's obligations, if you will, compliance with site plan. So this language has carried through from day one, that the developer is obligated to comply with the site plan. At this time, the site plan was Exhibit C. When we get to the Third Amendment, it is now Exhibit A. The First Amendment, if you will, again, there was no change in the site plan. The original site plan, if you will, I'm going to get to it here. And again, this development agreement was prepared specifically for these tax parcels, which at the time were actually 125, it says 42 and 43. Again, these are the 5 tax parcels, 5 tax parcels. The site plan that was associated with the project, if you will, was Exhibit B, and that really dealt with the property that Mr. Mohideen owned, which again was the Dash-In gas station facility and what was a storage building that became the Hitching Post Pizza. And again, this was the parking that was associated with the first two development agreements, the original plus the First Amendment. The site plan did not change on the First Amendment. The second, this is the First Amendment. Again, all that did is extend some deadlines. The developer still had obligations to comply with the site plan. And the Second Amendment, again, the agreement still contained the obligation of the developer to do the development in accordance with the site plan set forth in Exhibit B. And we spent some time talking tonight about the Elks, and I think by way of background, if you will, the city has all of its meetings on video. You can watch this yourself. What I'd like to do now is to provide that perspective. I think a lot of folks, perhaps in the community, might not know the history. They know today. They know that we're here today talking about these particular citations and an appeal, but how we got here really was through, in 2009, with an original development agreement, an amendment to accommodate Mr. Mohideen, and then a second amendment because the bull riding arena was proceeding. The city and Mr. Mohideen worked together to amend the development agreement in the second amendment to allow the bull riding to continue. So Mr. Esquivius is the planning manager. Rudy was here at the time. And so there's 3 excerpts I'm going to play here on relating to the Second Amendment, and I'm going to see if I can do this correctly, see if I'm as challenged. Open hyperlink. So this provides some history on the background.
2 separate votes on these here, so. Rudy?
Thank you once again, Mr. Mayor, members of the council, ladies and gentlemen. Mr. Mayor, the subject property is located at the southeast corner of North Apache Trail, which is also ADOT Highway 88, and East Superstition Boulevard. Presently on the property, there is the Hitching Coast Restaurant, there's the Dash-In convenience store, there used to be a gas canopy with gas pumps in this area. That use, for various reasons, has been discontinued. The original site plan for the property was approved subject to a development agreement when the restaurant was being proposed. Under the original development agreement, there were certain breaks, if you will, given on the parking requirement in exchange for landscape planners, in exchange for some economic development. There was some development fees also waived as part of the original Hitching Coast approval. So the reason this is before you tonight is because there is a development agreement that is locked onto this property, and part of that development agreement included a specific site plan. Now, the applicant proposes, once again, to get rid of the gas station use, and instead, in the general area, he would like to offer or create a bull riding venue. There's a couple of these in the valley. One is up in, I think there's 2 of them up in Cave, or one of them's up in Cave Creek called the Buffalo Chip. There's another one up in the New River area. I think there's one at Rawhide. But basically, it's a circuit. There are bull riders who go to these establishments, and they put on bull riding shows. It's just like real competition. It's like these little mini rodeos. The patrons are there enjoying the food, they're enjoying the music, they're enjoying the atmosphere, and then when the band takes a break, the folks are invited to go outside and witness the bull riding, and that goes on for about 20 minutes. I think it's like a 20-minute on, 20-minute off, 20-minute on kind of thing, or every hour or so. And so there's multiple things going on at these venues. And Mr. Mohudeen would like to do a similar kind of venue here. But the issues that we have basically is that, number one, the existing development agreement needs to be redone to accommodate some of the parking that was done on the original development agreement. Since the Hitching Post restaurant was established, very early we discovered that the parking arrangement under the original development agreement didn't quite work out like we had envisioned. Like I said, it was very tight on parking. There was some administrative discretion granted to the number of parking spaces that would normally be required. For example, because the convenience store hours basically end at 7 p.m., we reasoned, okay, well, the spaces next to the gas pumps could technically be considered parking spaces. I don't think anybody ever knew that they were really parking spaces. So very early on, folks started parking in this adjacent lot. And Mr. Mohudeen has made an arrangement with the property manager of this property to rent this property for the purpose of off-site parking. And that becomes very important when we consider this bull riding venue, because most of the parking is going to need to be contained off-site. Back in January and in February, I think it was, when this idea came to us the first time, there was also the thought that the folks across the street at the Elks Club could also be used for overflow parking, and so he had a couple of accessory parking lots. At present, it appears that the Elks Lodge is off the table. They need special board approvals and membership approvals before they can enter into that kind of agreement with Mr. Mohudeen, but this property is still under lease. As a matter of fact, in your packets you have a copy of a renewed lease. So that is the basic nature of the request, Mr. Mayor. Mr. Stern also mentioned the extension.
So Mr. Esquivius talked about that this development agreement was locked to a site plan. I think he used that language, and that it was tied to a specific site plan. Attorney Ralph Pugh was representing Mr. Mohadeen at the time, and his description, it really goes back to what was talked about earlier about the Elks Club. The Elks Club parking went away. So the only parking that became available was, as Mr. Pugh will say, is to the south. So it really goes back to the point of he explains very articulately how this got started and where the parking's going to be.
Honorable Mayor and members of the council, thank you very much for the opportunity to be with you this evening. My name is Ralph Pugh. My office address is at 1744 South Val Vista Drive, Suite 217 in Mesa. It's a privilege to be here on behalf of Mahmoud Mohudeen tonight. A little difficult to get that straight, but that's where we are. Mayor and council, this issue seems to have taken on proportions of grandiose problems, and I'd like to try to answer as many of those questions as might be in your mind as possible tonight, and to take just a minute and refresh our memory as to why we're here. This is not a zoning case. We are not in front of the council tonight asking you to rezone a piece of property so that a bull riding venue could be approved. That's a separate issue. We're not here asking you for a special use permit that requires specific findings to issue that permit. This is a matter of requesting of you an amendment to an existing development agreement that is in place on this property. The property is zoned CB2, and an outdoor entertainment venue, as this is an allowed use by right in that zoning district. The reason we're here tonight is because a development agreement was previously approved. And with that agreement came certain obligations and responsibilities from the city, but more specifically, the property owner. And this request tonight involves an amendment to that development agreement to allow this use for the reason that there's not enough parking on the site itself. This is a classic example of what we call in the land planning business, remote parking. Many municipalities have codes that authorize remote parking as a matter of a mathematical calculation. You turn in the agreement with your neighbor, you got the remote parking, everything works. Your code is different. And so in honor of that code, we're here tonight to amend the development agreement asking you to allow this venue with the specific recognition that additional parking will be necessary at this point on the south side. And I can explain to you the issue with the Elks here in just a second. So I don't mean to bore anybody with it, but that's really why we're here. That's the request, and that's what's in front of you, along with, as the city clerk indicated, the permanent extension of premises permit.
So that site plan that's we've seen tonight in exhibit as part of the development agreement for amendment number 2, again, is this site plan here. So this is the land that Mr. Mohadeen leased from Zion. So we do have a copy of the lease in your packet.
Larry, real quick, is this parking lot what is now the facade?
Correct.
Okay, thank you.
Yes. We have a lot of exhibits. So I'm looking for the lease that's between Mr. Mohadeen. Again, it's the subject of this particular meeting in 2013, that right after that, Mr. Mohadeen, and it's very specifically talks about where the lease area is. So the lease area is the leased area immediately south. It's described in that lease agreement. It's not to the east. It's not on the other Zion property where the Park and Save RV boat and storage facility is. Was that 14? Thanks. So if you go to Exhibit 14 in your book, and again, I can put it up on the screen. The location is the vacant lot directly west of the Park and Save storage lot, east adjacent to Highway 88, and directly south adjacent to the Hitching Post Pub and Dash-In Mini Mart. And it has that legal description, which again, there were 5 parcels here, many of which this facade town where the parking is today, there were 3 parcels that overlap there. So again, the second development agreement, where's my thing here? Again, dealt with the that parking to immediately to the south. Parking was never contemplated. We heard that the Elks did not make their property available for parking because it had to go to a higher authority, and the parking then became what the city was talking about was to the south, a leased area. Parking was never contemplated to the east. The third amended development agreement, again, all these carry through with regard to the language regarding the obligations of the developer. In this particular case, the site plan that originally attached to the second agreement referenced in B3 of that second agreement is replaced with a new site plan and supporting documentation as set forth in Exhibit A. So again, that is this particular site plan. This property that's highlighted in yellow, that was the original property that Mr. Mohadeen owned that was part of the Dash-In and the Hitching Post. So the site plan at the time in 2014, again, was not owned. The additional land was not acquired by Mr. Mohadeen. The third segment really relates back to enforcement of these, and Mr. Mohadeen was represented.
That's what brought up the safety code issues of ingress, egress, size of those exit doors, sprinklering, all those issues are building code issues that the owner will have to deal with if the council approves the amendment to the development agreement and the extension of premises. With respect to parking, how the whole issue from the Elks Lodge arose, we don't know. The owner had an agreement with someone who appeared to have authority on behalf of the Elks Lodge. What happened to investigate that further, I have no clue. But if what we have heard is true, then indeed authorization to allow a lease with the Elks must come from a board of directors on a grander scale than the local club.
It's called the Grand Lodge.
That's what it is. It's the Grand Lodge who has jurisdiction over all of them. So for our purposes tonight, let's all assume no lease exists at the Elks. We don't need it. It's not necessary. Now, can we negotiate with them and meet with them in the future if necessary? Yes, but right now, that's not on the table for this very moment, and it's not needed for the site. The development agreement, council members, clearly addresses that issue. And by the way, we agree, and we're on the record tonight, we agree with the revised draft of the development agreement as it relates to restrictions on parking and what happens if it's not available. And in answer specifically to 2 questions council members raised at your work session, I think it was, I can't remember now, Councilmember Wilson asked a good question about something to the effect of how are you going to know if the lease is terminated? How will the city know? We've inserted a provision in the development agreement that requires the owner to notify you within 10 days after the lease becomes terminated for any reason. Then a more interesting question came up, not to say the first one wasn't, but this one's even more interesting. What happens if the extension of, if the bull riding venue terminates for whatever reason? The extension of premises, if you recommend approval and if the State Liquor Board approves it, theoretically still exists. That's an issue with the State Liquor Board and the owner, but we have agreed as the owner to contract with you as the City of Apache Junction that if that venue terminates, we voluntarily.
So that part related to the liquor license was not necessarily germane. I could have cut it off earlier. The point is that Attorney Ralph Pugh said it was clear to them where parking was going to go. They went into the Second Amendment with eyes wide open that there was going to be a lease to the property to the south. They didn't need the Elks Club. I think it satisfies that they could accommodate all the parking right where they're at. The final segment now relates to the third amended agreement, which again, that site plan is tied to it. So there was the amendment to, the third amendment to the agreement. Essentially, that whole purpose of the third amendment was to tie in a new site plan and a bunch of exhibits that related to the, I guess, the building code integrity of the bull riding arena. So all those are attached as exhibits. But this relates to, I guess, the issue of enforcement is and I'm going to skip ahead because the first few minutes, I'm going to go to 3 minutes and 42 seconds where Mr. Pugh starts talking.
Mayor and Council, we're here on the third amendment to the development agreement with respect to the bull riding arena at the Hitching Post Bar and Restaurant. The reason we're here is very, very simple. In October of last year, this council approved an amendment to the original development agreement authorizing the bull riding arena. When we all left the meeting that night, we thought it was a relatively simple process to implement that. Well, thanks to the input from Mr. Dixon, Mr. Stern, and others, we learned that it wasn't quite so simple. So all of the amendments in this agreement that affect the site plan, which has been slightly tweaked, floor plan of the restaurant, which has been designed correctly for exiting and fire safety procedures, gates, locking mechanisms, signage, all of the protective issues you were all very, very interested in that we didn't have good answers to in October have now come to fruition and are all enumerated in the agreement very clearly. Also, there are substantive provisions about insurance that covers the city in two respects, both general liability, which is very typical of most commercial enterprises, and then we have another policy from the stock provider. This agreement also enumerates the very specific fencing that will be installed. It enumerates who will do the installation. It describes the methods whereby it has to be complied with. And most importantly for all of you, all of that has to be done before the certificate of occupancy is issued. So Mayor and Council, we thank you for your attention. I'm happy to discuss any specific item in the amendment and urge your approval of it. Thank you.
Councilmember Wilson? Yeah, excuse me. I apologize. And I appreciate the addressing of the sound system and the lights in the aspect, because the only concerns that I have received was from neighbors worried about the flooding of lights in their area as well as the sound system. And I'm going to say the insurance that's being added to include this coverage of the city. My question kind of goes twofold in this, is number one, we've had some, I'm going to say some experiences in the past where things were not completely followed through on it. What is the reassurances that we can have as council that if we vote for this, that Mr. Mamu will follow through exactly what you have promised and what you have said, as well as on this complete document?
Mayor Sulaco, Councilmember Wilson, the answer to that question is the following. Number one, the development agreement and its enforcement provisions will be signed by Mahmoud himself, and he'll be bound by it. Number two, certificates of occupancy will not be issued until all of those things are in place correctly. And number three, if there's a violation of those provisions during the duration of its operation, under the contract that you will have with the city and him, it's a breach of that contract and it would be subject to enforcement. So I can't think of any better ways to bind it than that, and that's what we've done.
Okay, thank you.
So this one, so that, those short snippets, if you will, really provide a little more history, I think, for the board and the community as to how, why we're talking about enforcement, and that the city, I think, as a agreement, development agreement, to be able to make sure that the agreement is adhered to. I think the city's gone along with Mr. Mohadeen and amended it several times as it needed to be, as his business plans changed and as what he wanted to do, how parking evolved. But I do believe that throughout this whole development agreement, the specific language that says there is a site plan and you're going to adhere to a site plan, and it related to parking. Specifically, the whole Second Amendment was about parking, and we're here primarily to talk about parking. So again, I wanted to also talk about this compliance agreement. So back in 2017, similar citations were written. Mr. Pugh then essentially said, yes, there were violations of the development agreement for parking, and the way to work through that was a compliance agreement. So there were previous code violations written for this specific item, as well as operating the bull riding outside of agreed upon times. Mr. Pugh worked with the city staff to create a compliance agreement. You have a copy of the compliance agreement in the exhibits, and that then resulted in moving towards a conditional use permit, which has always been an avenue to either expand the operation, amend parking, hours of operation, et cetera, et cetera. So that example on paragraph 4 in Exhibit 6 really spells out the idea that there was already compliance going on before these most recent citations. So again, in the Economic Development Agreement, that Section 3B essentially says that it obligated the developer to build the project and approve the property in accordance with the site plan as Exhibit B, which is now Exhibit A in the Third Amended Agreement. So in the presentation earlier, there was really a focus on the second agreement and the site plan from the second agreement. And I believe it was said that that really, what's crucial here today is the Third Amended Agreement and the site plan. And essentially this, this area here, it says leased parking lot. So again, the leased parking lot, this is Exhibit A in the Third Amended Agreement. We did take that Third Amended Agreement site plan, we overlaid it over I believe this is a 2017 aerial photo, would be late in the year. The arena is fully built out. That site plan, again, is just simply superimposed where the parking would be. There's no parking shown at the Elks, there's no parking shown to the east, etc. This is later in the year, or again, I apologize, could be, this is dated, the imagery date, this is not in the city GIS system. We do purchase our photos from the Maricopa County Flood Control District, but this is a Google Earth image that shows the parking lot no longer has the RV boat storage in it anymore, and it is patron parking. So again, depending on what the board feels here, is that part of our struggle with this is that Mr. Ludwig made the original application. Then there was a second document submitted that alleged different rationale, if you will, for why the zoning administrator erred. And now tonight we hear yet a third set of arguments for why the zoning administrator erred. So we don't believe that parking is permitted to the east of the hitching post dash-in either of the site plans. I did want to go to the citation because I think the exhibit, I'm going to escape out of here and go to either one of these are they're in Exhibit 2. So this is the notice of violation. The bottom paragraph talks about you're in violation of the zoning code in section 1-16-13, which is the relevant section related to development agreements, which limits the use of the property in accordance with said agreement and the uses and areas specified on the site plan, which is an exhibit to the development agreement. You are violating the agreement by using the land east of the hitching post for parking. Clear violation of the economic development agreement and constitutes a violation of the zoning code, which is that section 1-16-13. I did want to, this was the previous NOVs. There were some questions earlier. This letter, this is the section that was shown, violations observed, but the paragraph before that is very important, I believe, in that you were notified in that letter that in order to use parcel 01C, that is now combined into this larger parcel. So now 43C encompasses that prior parcel. So just by combining the parcels doesn't make the development agreement go away or the site plan. So parking outside of the site plan is the infraction. It was formerly 1C, 100-25C. So again, subsequent submittals on behalf of the applicant have said that either parking is somehow a permitted use, either under the old zoning code or the new zoning code, or that it's grandfathered. So Mr. McKee indicated in his submittal that the boat storage, what was a boat storage lot is actually parking. So boat storage, RV parking and boat storage was a permitted use in the, it's actually C3. It's not CB3, it's actually C3. So C3, in your packet, you have a copy of the zoning code that was in effect prior to 2014. So the permitted uses were RV boat storage, RV and boat storage, but not parking. There's nothing in the prior zoning code or even in the current code, and I'll get to that in a second, that it was a permitted use. So parking, it was never a parking lot, it was an RV boat and storage lot, and it was Zion International. So it's not grandfathered because it didn't exist. There was no patron parking in that area to the east of the hitching post. And again, I mentioned this earlier, Mr. McKee seems to think that it's allowed to the east. So somehow the south equaled east. And so in his statement, which is included in the packet, I believe it starts at it's Exhibit 10. So in Mr. McKee's exhibits that he submitted on behalf of Mr. Mohadeen, the word south somehow changes to the east. And then I think what's at heart here, too, is that combining parcels somehow makes parking permitted now. And that completely ignores the economic development agreement and the site plan that's attached to the economic development agreement. So you've seen this chart before. Again, I would argue that the original appeal by Mr. Ludwig is really what's before the board. However, by virtue of all these seeking continuances, additional information keeps being submitted, different arguments are being put forth that, again, the board has to consider whether relevant or not. I think staff has put together the memo with regard to Mr. McGee's that explained that Mr. Mohadeen, if he thought parking was grandfathered there, the city has a process to apply for a letter of lawful nonconformity. That's never occurred. So if it was grandfathered, first of all, I don't think it ever existed because it was an RV boat and storage lot, but if parking, customer parking was grandfathered, the city has a process to seek to apply for a letter of lawful nonconformity.
Mr. Chairman, I have a question. Sorry, can you repeat that one more time? I just didn't quite follow that. So if they wanted to have that parking grandfathered in, the city would have to?
No, Mr. Mohadeen
would have to submit that application?
Correct.
Okay.
Yes.
All right. It just made it sound like the city had to fill out that, and that didn't make sense.
No. Correct. Yeah, Mr. Mohadeen did.
All right.
The, in your exhibits, you do have a copy of the former C3 zoning district. that explains it, that it was not a permitted use. Do you want me to go through that?
If you can just point me in the right direction.
All right.
Sorry. I just want to make sure it's clear in my head of what's,
Page, paragraph, subtext, you know.
yeah.
Exhibit 11, this property let me go through Exhibit 11 first.
Yeah, that's where I was, okay.
This is Exhibit 11. This is Ordinance 511. This is the ordinance that was adopted, and again, sorry for the scanning of the old copies, but this rezoned this property to C3. So this property is zoned C3 by Ordinance 511. The remainder of the property was zoned CB2. And again, we're talking about the CB2 property is this property that's outlined here in that triangle on the previous page. So this property was specifically rezoned to have an RV boat and storage lot under Ordinance 511. And that's where one of the Zion International, if you will, but the Park and Save.
So Zion International owned multiple properties around that, and in the from the city's point of view, in that original lease agreement, the land, what they're calling to the south, which would be, can you flip back to that last one so I can just.
Sure. Just
north of East Foothill, of the E.
This property here.
Right, no, sorry, to the left, no, to my left.
So here, again, this
Go
is
right.
where the hitching post dash-in was.
Correct.
And again, there were 5 parcels total. The house
okay,
was
so-
included in here, and multiple
Okay,
storage
so
yards,
that's-
if you will.
So that's, okay, I'm with you now.
Okay.
And then to grandfather in the parking, at the time that was happened, Mo would have had to submit an application to, if he considered that a grandfathered in, he would have had to submit that application at that point.
Well, again, this was an argument that this Mr. McKee was making, and I was just trying to say that we don't feel that was grandfathered.
Right.
It's not, it may or may not even be argued anymore, but when the July, or the May 13th meeting happened,
Right.
a whole new set of arguments on top of Mr. Ludwood's arguments were
brought.
submitted.
Okay.
And so therefore, we were trying to go through those, each one of those, and try to provide an analysis of whether.
Okay. No, sorry.
So either was it allowed to the east? Well, what was allowed to the east was what was under that Ordinance 511, which is an RV boat and storage yard.
Right.
And then, in fact, the aerial photos show that that was an RV boat and storage yard historically.
Yeah. Okay, I'm clear now, I appreciate it.
Okay. And the former zoning code is also included in your packet, and the C3. So this is also part of that exhibit that explains what the permitted uses are in that zoning code. And in that zoning code, this paragraph 5 deals with storage of automobiles, recreational vehicles. So that was a permitted use back in the day. Again, this was the boat storage yard, which again was an allowed use, but again, the distinction being made that an RV boat storage yard is not a parking lot. It's not customer parking. It is a specific use allowed by zoning. That's the lease. Another item I'd like to, again, this is in your packet. This is Exhibit 20. And again, the statements were made or are being made that parking is a permitted use. So this is the city's current enacted zoning code effective June 5th, 2014. And in Table 5-3, which is Section 1-5-3, and if you go, again, it's in the book, but it's on page 6. And the type of parking that's allowed are commercial parking lots and garages. And the first column is B1, but you'll notice that it says CUP. So a parking lot is not A commercial would be a commercial parking lot. Again, I don't believe we have any in the city that, again, you would go to a city that has where someone privately owns a parking lot and then leases spaces out. So to have a commercial park, so the only thing in the zoning code that relates to parking as its own use. So it would be the principal use would be a parking lot.
Larry, sorry, Mr. Chairman. When was you just said when this new zoning code was
It became effective June 5th, 2014.
after the second development agreement?
Correct.
So what was the zoning code prior to June 14th,
That's what I believe I just showed you in exhibit, the back of exhibit 11, the C3. So that's the prior zoning code is part of that exhibit.
Which is 1-16-4-10? Or was that the parking?
It's,
I'm sorry.
1-16-5 is the C3 General Commercial District, and it's under subparagraph 2C5. Again, I'm going to I guess the notion that it's always been a permitted use to have parking there, and that's not the case. The permitted use was an RV boat storage yard under the C3.
But it says automotive and light equipment. Is automotive not a vehicle?
No.
Storage.
No.
Hold it down, please, out there. Thank you.
It's a storage use. Storage of automobiles, recreation vehicles, and boats. It's not a customer patron parking area. Mr. Chair, could I expect some decorum, please?
Yes.
So Exhibit 20 does list the city zoning code, and on page 6 of that, I listed that it takes a conditional use permit just to have a commercial parking lot. Also, there's been reference made to the very back of the table. So on the back of the table, which is page 10 of that printout of the city zoning code, the permitted uses in the B1 through 5, and then the public and institutional are from left to right in that column. So those sections of the code that say C, temporary uses, see a different section of the code, signs, lighting, et cetera. Those are not permitted uses. Those are references, for example, landscaping. If you want to go look at the landscape code, that's in Article 1-8. If you want to look at the parking regulations, how big a parking space can be, not the zoning use of a property, but where the regulations that regulate how parking lots get built, that's in Article 1-7. So I just wanted to make sure that folks know that that section of the code where it starts with temporary uses and structures, those are simply referring the reader to different sections of the code that relate to not permitted uses, but other regulations that apply to a property as well.
Mr. Chairman.
Braden.
Larry, can I go back to the prior zoning code? On the page prior to bullet 5 that you just showed me, I'm reading, it says the C3 zoning district, some other stuff, but various applications of the C3 district can create community or regional shopping complexes, central business districts, certain highway-oriented commercial uses, or small but highly diverse commercial development. So nowhere in there does it say parking, storage, any of, I don't believe, I mean, I personally have never gone shopping at a RV storage lot. I've gone.
Hey, please.
I've gone to eat, however, at regional shopping complexes. So if I look at that and then turn the page and look at principal permitted uses, while I understand that you are saying that it states storage of automobiles, prior to that, prior to the semicolon, actually prior to 3 semicolons, it states automotive and light equipment. It does not state parking. It does not state storage until after that. And if I look at the site plans state parking and storage. And this would be prior to the zoning changes where we are now in B2 zoning, which would have, the second economic development agreement would have been grandfathered in under the old zoning codes.
That's not correct. So these are the permitted principal uses. It says, it doesn't say parking because parking is not a permitted use.
It also doesn't say storage or RV storage. It says
Storage of
regional
automobiles, recreational vehicles, and boats.
Correct, but
That's a permitted use.
But on the page prior, where it's general commercial district statement of legislative intent, it states various applications of the C3 district can create community or regional shopping complexes, central business districts, certain highway-orientated commercial uses, or small but highly diverse commercial development.
Yeah, I think all that fits in there, Braden. Oh, even the RV parking.
That's what it reads. I'm not arguing that it doesn't read that. The question is whether or not customer parking was an allowed use or a parking lot that you rented parking spaces out as a parking lot that was ancillary to a business is a permitted use. The permitted use that was allowed under the C3, the purpose of the rezoning was to allow an RV boat and storage lot.
Okay, so at the time then, the lots were separated because there was parcel 001B and 001C, correct? 001B would have been what is the facade, or it still is the facade. And that was leased space from Zion, and that was 001B, correct?
And what you see before you now is what Mr. Mohadeen owned at the time of the agreements up through the second amended development agreement, and even the third, was he owned what is shown there as 43A. You can see that what's 003, part of 001E, and part of 01C are all now in that area that is surrounded by the western facade that was part of the subject of the development agreement and the site plan. Those constituted 3 parcels.
Okay, so 001B at this time no longer exists. You had 001B earlier, which was the facade. I don't remember exactly where you showed it. I believe
Well, in the development agreement,
I believe it's a part of the second development agreement where that was a separate parcel and that was still being leased at the time from, or by Mr. Mohadeen from Zion International. And that was a separate.
the description in the lease is not on a parcel. It's like a meets and bounds description of an area that actually encompassed 3 parcels.
Right, I understand that.
Okay.
But per the second development agreement site plan, which I'm looking at right here, 001B was its own parcel, 001C was its own parcel, and then the parcel that has the hitching post, the buildings, the bull riding was a third parcel. If you go back to the second development agreement site plan.
First Amendment. This particular site plan?
Nothing's changed.
This
I think you still have it on the projector screen.
Oh,
You
I'm sorry.
No, you're fine. Can you scroll up just a bit? Correct, this site plan. So right there in the upper left-hand corner, which it says in very, very small print, and I apologize for those who can't read it, it is 001B, parcel 001B, and the very last line is parking and storage yard. It is the very last line. If you scroll down on your screen and look at parcel 001C, it also states parking and storage yard. So why are the 2 parcels as separate currently, both being leased by Mr. Mohadeen, being given 2 different classifications if they're not zoned, or if they're zoned under C3 at the time, I can't.
CB2, this area was
CB2.
zoned CB2, the other one was C3.
So if that's zoned,
So let me understand the question. So this is the property that Mr. Mohadeen leased from Zion that is described in that lease agreement to be south of the hitching post and to the east of Highway 88.
sure, I'll go with that south.
Okay. Well, there's a north arrow there, so
But
that would be south then?
I
It was
mean-
described by Mr. Pugh as to the south.
I also currently view 001C as south. That, I guess that's a matter of semantics, and that's another question I have, is how we determine the direction of parcels, but I'll get there.
Okay. So the question again?
So my question is currently under this site plan, per your belief, the parking lot, which is now the facade, is the south parking lot, which is zoned, and per the site plan, as parking and storage yard, which is the same zoning as 001 or 0001C, which is the off-site parking that has not even come into play yet. So why are those two lots, if they're zoned the exact same way, given two different classifications on what is a parking and storage yard and what is a, as you said, a general parking lot for everyday use?
There is no distinction being made here. The city allowed this area to be used as parking. It was part of all these parcels that were, other than the hitching post and the dash in, everything else around it was parking, was an RV storage lot. For boat parking, there's semi-parking there, all of that was used.
Yes.
I'm making the distinction between a parking for patrons versus an RV boat storage lot.
Okay, Larry?
Yes, sir.
If you'd scroll this all the way, the other way. On the small print right there, I think this is part of what Braden is referring to. As it says in the bottom line there, the uses is parking and storage yard.
Correct.
And that caused me some question also, is it does say uses of that property is parking and storage yard.
That's what it says.
Hey.
Can't
So
debate that.
please try to hold down any reactions. So that's what caused me some confusion there, is it does seem to indicate that lot has been used for parking. Now,
And-
whether it's long-term parking, short-term parking, we can debate, but that's not specified in that statement there.
Well,
Now, at this time, I would like to take a 10-minute recess, and we'll come back to this. I think we take a break. We'll be back here at 9:32. Let's reconvene. Larry, would you like to continue, please?
Thank you, Mr. Chair. This is Exhibit B to the Second Amendment, which was replaced by Exhibit A in the Third Amendment. So the notation that's on this drawing is the applicant provided this map It doesn't, this is not a city zoning map. The fact that this map says it's parking and zoning, it's not the city's map. It's a map prepared by the developer, and it's been replaced. So this map is really not relevant to the discussion, only to the point that this area was intended by Mr. Mohideen to be parked as part of the site plan to the south of the existing hitching post. And Mr. Pugh spoke in front of the council saying parking was not a problem. We don't need the parking at the Elks Club, and this is where the parking is going to go.
So you're,
As far as the most recent site plan is Exhibit A. It's been replaced in the development agreement, and that Exhibit A map and all its attachments is actually in the next, is over here. That says leased parking lot. And I could say the contrary. To the contrary, it doesn't say parking and storage over there. So it's really, it's not part of the overall discussion, what Exhibit 2 said that somebody put on a map.
Mr. Chairman?
Yes.
It's been an objection, and probably well taken, that there's a lot of noise coming from the
Yeah, folks.
We could ask that to hold till the public hearing. We appreciate it.
Thank you. Yes, please, let's maintain silence and let the people speaking speak. Thank you.
Mr. Chairman?
Yes.
So you're saying that this Exhibit 17 is the exhibit that was the finalized site plan for Amendment 2?
3. This exhibit right here is the Exhibit A for Amendment number 3.
And this is in correlation with the clip that we saw that said we don't need to worry about the parking up north because we've got the parking all taken care of. Or the parking.
Progression of this is that when Amendment 2 came around, the Elks was in play, but where Mr. Mohideen planned to do the parking, in Amendment number 2, his representative said, we don't need the Elks Club. Parking's going to happen to the south. This exhibit here for Amendment number 3 has more details on it which relates to the bull riding and where ADA exits were going to be and where gates were going to be, and the parking still shows leased parking area. How ADA was going to be, how ADA was going to be handled, where emergency gates and things like that. That's what the purpose of Amendment 3 was to solidify, and in the packet you have the entire appendices to the development agreement, which get into great detail about lighting and fencing, but what is important is the site plan.
so Larry, this site plan, Exhibit 17, you're saying is the official city site plan as opposed to what was in the second development agreement, which was provided by Mr. Mohideen and I believe Ralph Pugh at the time?
What I'm saying is the exhibit, what was Exhibit B in the Second Amendment became Exhibit A in the Third Amendment. This is, again, a site plan prepared by Mr. Mohideen's professional. It's stamped by an engineer. This is what became Exhibit A in the development agreement. And again, the point being, at the time, Mr. Mohideen owned the land in the yellow area, and that's it. And the parking was going to be off-site to the south.
Okay, but I follow you.
Okay.
Per the second development agreement, which I will go back to here, eventually. Use of the outdoor bull riding arena is conditioned upon shared parking agreements for overflow off-site parking on vacant property to the south or across from Lost Dutchman Boulevard. So again, this being the second development agreement would be the Elks Lodge or what is now on the screen as the leased parking lot, correct?
Correct.
Okay. It continues to state, should both of these shared parking agreements be terminated for any reason by the off-site property owners represented in said parking agreements, the leased property to the south or the Elks Lodge, All outdoor activities with the extension of premises area, including but not limited to, will cease if, did I skip a line? I think I did. There's a statement in here in regards to the off-site parking, that there
On
has
page
to
2, I
be.
think I have it on the screen, Mr. Biggs. Is that what you're talking about?
Yes, it is. So until comparable off-site parking arrangements are secured. It doesn't say if that's the Walmart parking lot on the other side of town and they're going to shuttle people in. It doesn't say if that parking is the leased lot, which is a different parcel at this point. It says off-site parking arrangements are secured. So at the time of this development agreement, even the third development agreement, Mr. Mohadeen did not own the property which you say is to the east, which is the parking and storage. He leased that property and was parking vehicles there, or began the lease of that property.
I don't have the exact date of the lease. The lease that we have is the lease that shows the Zion area to the south.
I understand that because
The east was still operated with a business license in the city as an RV boat and storage yard by Zion. And it was not acquired until after the third development agreement.
I understand that. And per the second development agreement, it says comparable off-site parking. So even that lot was still zoned under C3 at the time, which still would have allowed parking on that lot.
I would disagree, sir. I think the code that I showed you says the permitted principal uses, and it says an RV boat storage yard.
I interpret that differently, but that's okay.
Mr. Chairman?
And the exhibit, I guess I wanted to say in terms of the third amended agreement, that essentially replaces all that language. All the language related to the Elks Club is gone, all the language related, it talks about the site plan, it's a new exhibit attached to that. So even at the council meeting on the Second Amendment, the council that night knew by Mr. Pugh and Mr. Esquivius that the Elks was going away. And yet the second amended development agreement was approved with just the parking to the south because Mr. Pugh said, what? We don't need it.
Okay.
Walker, you
Mr. Chairman, yeah, so in that same section that Braden was just reading from, it does say that if that agreement is terminated, then the burden falls upon Mr. Mohadeen to within 10 days reach out or cease operations. There's also the November 16th, 2016. Now, I realize this burden does not fall upon you, but is there, and maybe I just missed it because it's a thick packet, is there a time after he purchased that land where he came to the city and applied for that type of parking or said, hey, we want to convert this into patron parking versus the current storage? And again, I know this burden doesn't fall upon you, but maybe I just missed it.
We had a process, and Rudy can be called upon for dates, but after the third amended development agreement, Mr. Mohadeen came back to the city and said he wanted to change some of the uses, add some other outdoor activities out there. By that time, he had acquired the property. The city went through a conditional use permit process with Mr. Mohadeen. The conditional use permit was approved by the Planning and Zoning Commission. The neighbors appealed it to the council. Mr. Mohadeen withdrew that particular CUP before it went to the appeal at the council. Subsequent to that, Mr. Mohadeen applied for another conditional use permit that I believe is referenced in Mr. Ludwig's appeal, is that there was a second application for a conditional use permit to go ahead and start using land that he acquired. So there was always two avenues. There could be a fourth amended development agreement to make that happen.
Which is part of one of the continuations. We have a note from Mr. Mohadeen saying that they're working on a fourth amendment to that, and so they asked us to continue.
And the other option was a different but a new conditional use permit, and that was applied for, and that was approved by the Planning Commission. It was appealed to the City Council. That the council did approve a conditional use permit for Mr. Mohadeen to allow the expansion of the use on now his larger parcel. That particular conditional use permit was revoked. I believe it was in July, I believe it was. So there were certain dates and obligations in that conditional use permit. Those dates were not met. We took it back to the Planning Commission. The Planning Commission said, well, these dates have not been met, so the city revoked that particular conditional use permit. So we're back to either a fourth amendment or we're operating today under the third amended development agreement.
Okay.
Mr. Chairman?
Yes?
So explain to me then where the compliance agreement comes in, because when in the compliance agreement, which I do see Joel's note as of June 7th of 2018, the compliance agreement is null and void per Joel because the CUP is now in effect. So
that was the second CUP. The first CUP never went into effect because Mr. Mohadeen withdrew it before it got to the council. So there was a CUP. It was in effect for almost a year or over a year. And so that part of the compliance agreement was an acknowledgement that there was parking on this land outside of the site plan.
correct, it's bullet point
Okay,
number
so, all right, so then, in order to remedy that particular code violation, a compliance agreement was entered into. Part of that compliance agreement, if you read further, was the obligation, if you will, to apply for a conditional use permit, try to establish a conditional use permit so that additional uses, there were talks of additional uses and weddings and events outside to the east, outside what was the original property boundary. That conditional use permit was approved by the City Plan Commission, again appealed by the neighbors, and then the council did approve a conditional use permit with 26 or 7 conditions, something like that.
Okay, but we agree that the city acknowledges that parcel 001C at the time of the compliance agreement, which I don't know when, November of 2017, that we would allow, that the city would allow parking to be there, even though you feel that it is parking and storage. You state that overflow parking relating only to the Hitching Post Pub and Hitching Post Steakhouse are allowed on 001C. So the city agrees that at some point in time, parking, not overnight parking,
The city does not agree to that, Mr. Biggs. The city signed the compliance agreement that said he could park there in the interim while the CUP was being addressed. The CUP eventually went away and parking could not go there.
But parking couldn't.
That was part of a compliance agreement.
But
not a development agreement, not zoning, it was part of a compliance agreement.
I understand that. So why the break in the code to allow parking for temporary periods of time if that's not even a parking or a parking lot? You say it's
not a break in the code. That is a negotiated compliance agreement with the understanding that Mr. Mohadeen was going to be working towards compliance by applying for a conditional use permit to ultimately try to use the land as he wanted to.
Okay.
Are we getting close? Again, we're back to this. Again, I hope tonight I've tried to explain what Mr. Ludwig tried to present. Again, you have that document, and I did quote it at the beginning, that essentially that parking over there was either a permitted use or it was allowed by the site plan. Mr. Ludwig says it was allowed by the site plan. There's no site plan that shows parking to the east of the bull riding, west of Cortez. There's no site plan that shows that that's okay to park there. All these other additions relate to whether something was grandfathered, whether it wasn't grandfathered. It's allowed by right. It was allowed under the old code. It was allowed under the new code. There's nothing in the code that we can find in the current code of 2014 or the previous code that allowed that boat storage RV yard to be used for parking for this operation. Again, this, I don't want to keep going through that because I just said that. So again, there is this, now Mr. Mohadeen went through a lot combination process. After he acquired all the property, as part of the conditional use permit was to get all these parcels straightened out. So rather have 5 parcels, today he has 3 parcels. He has the house parcel, he has an additional storage yard, and then he has this larger parcel that we saw the map of earlier. So combining the parcels doesn't change the economic development agreement. The economic development agreement is tied to a site plan that was attempted to be resolved amicably with a conditional use permit. That has not happened. We don't have a Fourth Amendment yet, so we're back to Mr. Ludwig's original appeal. So again, our case is that it's a violation of the Third Amended Development Agreement. So a violation of the development agreement is, the development agreement language is in the zoning code, so therefore it's a zoning code violation. So again, those are the options. So in the staff report, we do have some recommended language, which you can see. I can answer any more questions, and of course, we have a public hearing tonight. Thank you, Mr. Chair.
Let's start here with Judy. Any questions?
No,
Jesse?
good.
Yeah, I've got a few. So the economic development agreement, do all businesses in Apache Junction have one of those, or is that a special thing for specific
It's a special thing. The city has done them in the past. We have done some, for example, a sales tax agreement. We had one, we haven't done one in 5 years that I know of, but the business will come in, have retail sales tax. The city will agree to reimburse them the sales tax for a specified period of time, very tightly controlled. We used to do economic development agreements, I think before 2012, primarily when the statutes changed regarding development fees. So in this particular case, it was a waiver of development fees, a discount, if you will, of $46,000. The city had done many of those at the time. The city has not done any since then. It's not practical for the city to waive development impact fees, development fees, because the city has to reimburse itself out of a different pocket. So we have not done an economic development agreement, I don't believe, since this one in 2014.
Okay, so this is a special case.
Well, again, no, the city had several development agreements. All those, again, were different types of developments where the city may have primarily done some sort of exchange for impact fees, development impact fees.
Okay. What use would Mr. Mohideen, in your view, be allowed on the parcel in question where the parking violation was? Basically, boat and RV storage. If he wanted to open up a boat and RV storage, he'd be allowed to do that?
Today, the code has changed, which would require a conditional use permit. It would require landscaping. It would require screening. That was the evolution of the code. The city has a lot of RV boat and storage yards. I believe we have 20 to 22 of them. Some of them came under where the codes changed and you had to do landscaping. Mm-hmm. So it would take a conditional use permit today to have a outdoor storage, RV boat and storage. And then that conditional use permit would come along with landscaping requirements, screening requirements, dust control, and some sort of fencing, screen fencing.
Okay. And I'll put this into a question. It seems like your stand is that the EDA is not changing just because all of a sudden there's more a property buffer around the original boundary of the hitching post.
That would be correct. That would be my statement, yes.
Right. And I think that's the crux of it, is that from your perspective, the original boundary of that economic development agreement is what the city is basing its case upon, and you're not going to allow the business to expand just because new property is purchased outside without the Fourth Amendment to the agreement or a CUP.
That's correct.
Okay. Thank you.
Walker, anything?
Sorry, yeah, one last thing on going back to where is it? Where you cite the original use of that land, the code. Sorry, can you help me?
I believe that was Exhibit 11, I believe?
Yeah. So in that, and then again, I do operate a business in Apache Junction, but I'm not super familiar with all the exact uses. But underneath this original agreement, the C, and it happened to be subsection 5. Sorry, no, I'm page 117 on 12, where you point out the automotive light equipment. So the original license that was put in at the time of this agreement with the other business, and I know we don't have probably a lot on that, but that was specifically related to RV and boat storage, or was that citing this code so that if they wanted to turn it into, let's say, an automotive lot, which would still be covered under this, that would increase traffic? Are we saying that the city, that's the only use for that was the RV and boat storage, or they have been able to, without getting the city involved, turn that into also a repair facility underneath this?
Now, all the uses that are outlined in that section of the code at the time, so it could be a agricultural, horticultural sales was a permitted
Right.
use. It could have been a nursery. It could have been animal sales and service. All those were permitted uses at the time under that C3 zoning.
Under that zoning?
Correct.
So if that, my one hang-up, and maybe this is not the appropriate time to say this, but my one hang-up with this is if that happened to not be an RV and boat storage, but it happened to be, let's say, an agriculture and horticultural sales and service, the traffic to that same lot would have been increased exponentially. But it seems that the crux of the argument is the frequency of cars coming in and out of that lot. And I understand the city's point of view, and I understand Mr. Mohadin's point of view, but under this initial agreement, it seems to read that they were able to, if that RV and boat storage happened to be a 24-hour storage facility, that the traffic to that would increase exponentially. Is that a proper reading of that?
How I would say that is that, again, I think it goes to what Mr. Gage said. The city's argument is that there was an economic development agreement that had a third amendment, that had a site plan attached to it. This property that you're talking about was not part of that site plan. So whether it was a horticultural sales, whether it was RV boat storage, the idea is that that property could not be used without a conditional use permit or an amendment to the development agreement.
Okay.
Reed, any more?
Thank you, Mr. Chair. Oh.
So, help me understand why the lot can't be used. So, again, just like Walker said, I forgot your name for a second. The additional lot, which is the RV storage, boat storage, whatever you want to call it. If somebody went, and I think this is kind of what you were saying, if somebody goes and opens up a business on there that falls under those permitted principal uses, a daycare. If I choose, if I'm circling the parking lot in the hitching post, which whatever land, leased land, owned land, anything along that line, and there is no parking, and I decide I'm going to go park in the daycare's closed at 6 o'clock at night, I'm going to go park in the daycare. The daycare's allowed to have parking there, correct? I mean, they're a business, they're allowed to have parking there.
They're allowed to have parking. They're required to have parking. The daycare as a business is required to have parking.
Right, and per the zoning of that lot, if there's a business there, they're required to have parking.
But
So,
that doesn't mean that patrons from one business can go park at another business, because that would normally be trespassing, unless there was, as Mr.
Please,
as Mr.
we don't need that.
As Mr. Attorney for Mr. Mohadin, Ralph Pugh had suggested, there's a section in the zoning code at that same meeting where to get off-site parking, you have to get a lease. So so if next door is a daycare and they close at 5 o'clock and the business opens up at 7, there is shared parking that can happen with a lease.
okay.
Or sometimes even an easement agreement, a shared parking easement.
Okay,
Because maybe another part of the day, the daycare needs the parking on the other person's property.
right, no, and I agree with that. Is there not?
There is no use there today.
Okay,
There is no daycare there, there's no nursery, there is no use there that has the need for a parking lot. It was an RV boat and storage lot since the I think 1986 is when it was rezoned to C3. So
But
it's
your
been there.
point was that if parking was to occur there, it would have to occur via lease. Mr. Mohideen had a lease with Zion International for that property.
Nope. Not for parking,
Not for that property.
not for that property. His lease was for the property to the south, to just to the east of Highway 88 and south of the pizza restaurant. He did not have a parking lease. We have no evidence that there was ever a parking lease
But
to the
you're-
property to the east.
But you're going back to Aaron Ludwig's original argument, correct?
No, I'm trying to follow all the arguments. That people are saying that on May 13th, a different spokesperson on behalf of Mr. Mohideen said parking could occur there, that it was grandfathered, it was not prohibited, therefore it's permitted. There was never a lease at the time of the development agreement for any other property except the property to the south that was also Zion International.
Okay, thank you.
Luciano, you have any questions?
I have no questions.
All right, that takes care of the staff's presentation. Would the applicant like to have any redirect response? And I encourage you to keep it brief as possible. Thank you.
Mr. Chairman, we had discussed that we're going to have a public hearing and then rebuttal. Did you want to do it in that order? Or would you prefer to
Okay,
do-
we'll go that way. Thank you. All right, this time, this is a public hearing. And I will now open this public hearing to the public. Please come forward, state your name and address for the record. Remember, each speaker shall have only 5 minutes to make their comments. Now, this time, I want to restate that it's to be kept civil, there are to be no personal attacks, and I would like members of the audience here to please keep quiet and let the people speak their piece. Thank you.
Mahmoud Mohyuddin, 2304 North Cortez Road, Apache Junction, Arizona. The previous arguing Mr. Biggs and Mr. Waldy going on with Mr. Larry Kirsch, they're questioning about the lease. Zion International have a lease with the hitching post. December 16 or December 18, 2015, Mr. Rudy Esquivias contact me and my cousin, Brother Z, please, CUP is got withdrawn, this property is a legal zone, can you draw up a lease to submit to the city for your parking? I submit that lease to the City of Apache Junction in 2015, December 2015. They have a copy of the lease and each parcel was listed that time. When they send me the compliance agreement and the violation in 2017, I mentioned, do you request the copy of the lease? And I submit it to you, you have it. Mr. Rudy Esquivia emailed me that lease. He said, I don't know why I have it, but it's not recorded lease. And I questioned Mr. Rudy, explain to me the statute of the United States or any municipality, lease need to be required to be recorded with the county. He said, I don't want to talk to you, tell your attorney to contact me. They have a copy of the lease in their file. They don't want to present it in their paperwork. Thank you.
Thank you. Would anyone else like to speak?
Hi, my name is Colleen Shipman. I live at 1615 West Mockingbird Street, Apache Junction, Arizona. I've seen the lease. It exists. You don't have to record a lease. And in fact, they took it to the county. The county's seen it. It's in the files. This is one of my strangest questions. From the time that Rudy got a hold of Mo and asked him about leasing, it was actually the city that came to Mo and said, will you lease your property as a parking lot? Other businesses do it. In fact, I think, Handlebars does it. They lease their parking lot back. Nobody asked why, he just did it. And so for 3 years, there was no parking violations. I parked there for 3 years, folks. Never got a parking ticket, never had a problem. Had several sheriffs walk me to my car after the bull ring, because there were so many people, because they're nice. And so the lease does exist. It always has. This was, I don't know. I was a planning and zoning commissioner for 6 years, and I think it's odd that the police department is issuing zoning citations. I've never seen a zoning compliance officer out there. We've been contacted by letters, but never has anyone showed up. They go by rumors. And so that's something to know. But I will vouch, there is a lease. I've seen a copy of it. Thank you.
Thank you. Would anyone else like to testify?
Good evening. Michael Schaub, 2278 East 6th Avenue, Apache Junction, Arizona. I don't do politics. It's kind of boring. Kind of wasted a lot of time in here. We're all tired, clearly. So let's get down to the nitty-gritty. If you could pull up that picture of the property that Mo owns, that nobody's allowed to park on. And I've never had the pleasure of breaking bread or spending time with either of you, any of you, in the hitching post, your families, your grandchildren, your children. Yep, that would be the one.
Other way.
I think we're upside down here. So, and one thing is driving me nuts. We all get lost in a round room, but we're not going to do it in here. So let's do the north, south, east, and west still. That would be north. That would be south. This would be east. And that would be west. We all on the same page there? Okay. We can cut out the boat and RV storage because I've been going to the hitching post since day one. Nobody parks in there. Period. End of story. Even if we did, Mo owns this entire property. That's like you guys inviting me to a party at your house, and if I park in front of your neighbors, I send you a citation. So when you have a party next weekend, and you buy your neighbor's house, say, okay, well, I don't want to get in trouble again. We'll do parking here, and I'll build an RV gate. And I show up with my family, and I get another citation. All this property that Mo owns, the city made him do agreements and made him purchase it. What more do you want from him? Like, does he have to buy the Superstition Mountains? If anybody's going to get a citation, it should be me. Michael Schaub, 2278 East 6th Avenue. I'm the guy. Horse trailers, horses, donkeys, you name it, put them all over there. You know why? Because that's where I spend time with my family and my friends and my children. So to give this man a citation to park in his own driveway is absurd. It's ridiculous. One of you mentioned, is this a special case? It absolutely is. Always has been. Behind me is a fraction of the extended hitching post family. Patience is a virtue, and this family has been very, very virtuous with this city. We all have name tags up here. There should only be 3. Plaza, Bull. We're not asking for anything special. On that note, I would absolutely say thank you because of all the times I've spent in this courtroom, you interact and you're calling people out on stuff that doesn't make sense and it's junk. So thank you. All right? But bottom line is, I own a residence. You tell me I can't park in my driveway, we're going to have an issue. tell me I can't park in my neighbor's driveway without a agreement, we're gonna have an issue. If I buy my neighbor's house and then you still tell me I can't park there, come on, what more do you want?
I think that's your time.
57 seconds. You awake? All right. Come on. Let's be done with this. We're wasting time, money. We all want to go home, go to bed. It's getting ridiculous. We all get along. Hell, if we did this in 3 weeks, you'd have a bunch of pissed off Canadians in here. This is what we do. This is where we hang out. And I encourage you to, come on, you want to make a video? Let's break bread. Come to the hitching post. We don't do 20-minute bull ridings. Have a good night.
Thank you. Anybody else like to speak tonight? Anyone else?
Tina Lovelady at 601 North Merrill Road, Mesa, Arizona. I've been through this since day one. Y'all complained we don't have enough parking for our bull riding. We can't have bull riding because we don't have enough parking. We have to lease this so we can do this. We have to lease that so we can have bull riding. Now we own all that property and you're still complaining. Make up your minds. You're complaining we didn't have parking for the bull riding. You wouldn't give us the bull riding, so we didn't have any parking. Now we got the parking, and now you want to take the bull riding away. I mean, it's like going over, like Mike says, going over to a neighbor's house and saying, I'm sorry, you got that property. You can't put your picnic table there. It's against the law. Can't do that. You're making these rules as it goes. You keep, every time we do something, you guys make a new rule. Just like the property, we had 5 parcels. Rudy came to us and said, you can't have 5 parcels, you can only have 3. Only 3 parcels. First of all, he told us we had to put it all under 1. And I told Mo, no, we're not putting it under 1. We put it under 3 because Rudy said, in the city of Apache Junction, you can't have no more than 5 parcels. So we put it under 3. Now, because we put it under 3, they change all the codes. They change everything. Why? You didn't have to change it before. Oh, wait, Mo owns that property now. So let's see if we can screw him and kick him out of here. You've already gave him 1 heart attack. Let's see if you guys can give him another one.
Would anyone else like to speak tonight?
Doug Ford, 704 East Beldomar Drive, Tempe, Arizona. I don't even live in this city, but the only reason I come to Apache Junction, right there. I come on Sundays, Friday nights, and Thursdays to the hitching post for Mo and the family. If I had, and I was looking to move into this city, not now. If this is the way you treat people, I'd move to East Mesa first before I get here. It is so, and let's get right to the matter of this. It's not this. It's the people on the other side, the neighbors who are complaining. They're the ones who don't want bull riding, who don't want a family atmosphere. The only reason people come from North Dakota, Minnesota, wherever, the hitching post. It's not this property or this. If he owns this land, it's his. He has a right to do what he wants. Like I said, it's not this. It's outside. Thank you.
Anyone else like to speak?
Hi, my name is Teresa Shaw, 39830 North Vincenza Street, Santan Valley, Arizona. I come to Apache Junction for many things. I bring revenue to this city. I come for my dentist appointments. I shop here for groceries. I come to the hitching post to visit. We have lots of people that come from various locations, Chandler, Ahwatukee, everywhere. We need a place to park, to visit this venue and enjoy friends and family and have a good time.
Thank you.
Thank you.
Anyone else?
Good evening. My name is Joseph Levette. I live at 10236 East Carmel Avenue, Mesa, Arizona. When I talked to Mo the other day, I went home last night and I started looking up codes. What? Not their codes, but the codes of property. It states in many areas that I read, and I'm sorry I didn't bring them out, that the property owner has the right to park anything on his property if he owns it. Now, these cities come out with codes for areas that just disrupt everybody. You know, he's got the right to have people park because of his business. He's got the right to put cars on his property. No difference than me. But just because somebody comes up with a code or somebody complains about something and they all of a sudden change the code, you know, he's going to pay the price, along with everybody that goes out there and everybody that knows him. I've spoke before about the last time I was up here. It's a shame that neighbors don't know how to get together and go over there and get it straightened out without going through all this. So I pull for Mo all the time, you know, and it's going to happen, whatever's going to happen. But he's got a lot of people backing him in this town. And thank you very much.
Thank you. Anyone else like to speak?
Okay, my name is George Abbott. I live at 532 North Thunderbird Drive, Apache Junction. Been there since 2003. I'm also a native Arizonan. My family's been around this country for a long time, despite my accent, obviously. However, I enjoy going out this place. It's a family atmosphere, and I don't see anything wrong. But there's one thing that I've been noticing, and you were talking about earlier when they lost the ability to talk with the Elks to be able to have some outsourced parking, and there was reference to something south. Well, some of the things you guys have been missing is the fact that, yeah, they lost the Elks parking up there, but the terminology of south, which is getting confused with forcing the issue about this one small area here, this area here, that parking lot that you call RV parking, is south of the Elks. So whenever the words were talking about something south, chances are they were talking about that parking area. But someone seems to have missed that. I would submit that you need to take a rethink about what we really want as a community here, and also think about how many businesses we've gotten and how many we've lost. And what our friends and neighbors who are coming down here, or winter visitors, are going to be expecting when they do come down here. And that's to have a wonderful time and enjoy our weather, our social atmosphere, and our friends and neighbors that we have here in Apache Junction. And we welcome them all. We don't want them to take and go away because someone decided to take one more place away from them so they can actually visit down here and enjoy themselves. Thank you.
Anyone else like to speak? Okay, last call. Anybody else? In that case, I'll close the public hearing and open up to rebuttal.
Thank you all, each and every one of you, for your time tonight, and I appreciate listening to all the arguments that we've presented. The primary argument, though, to kind of come full circle back to the beginning of the day is, did Mo break the law? And we've discussed a lot about interesting zoning issues and grandfathered uses and all this. The violation that Mr. Mo has been cited with is a violation that in big bold, in the area where it says citation and violation in action, it says what we stated earlier, which is that that parking is not allowed or is not permitted under that economic development agreement anywhere on the property. That's just not the case. Parking is allowed and it is available on Mr. Mo's property. And in that respect, it becomes a simpler hearing. What we have, though, in addition to that, just kind of sum up some of the key points that we heard from Mr. Kirsch. You do not hear Mr. Kirsch indicate clear language that prohibits parking on the Zions International lot across the street and to the south of the arena and the Elks Lodge. And the focus, now this is an important point, okay? The focus tonight by, in the comments by respectable Mr. Hirsch has been whether the economic development agreement permits parking, okay, permits parking. When you're being cited with a criminal violation, there is a thou shalt not component to this. Where is there is no language that has been cited to tonight, and there can't be, that says thou shalt not go and make an arrangement for off-site parking in that Zions International lot. What we also heard Mr. Hirsch say tonight is that the economic development agreement it's confined just to the area that Mr. Mo owned at the time of the economic development agreement, just kind of in this area right here. Now, in that respect, the economic development agreement has no effect on prohibiting parking outside of that area. There is no way to hold someone criminally liable for parking outside of that area, for off-site parking outside of that area, if even given the notion that the economic development agreement should be limited to just the land that Mr. Mo owned at the time. You can't hold that someone broke the law when the agreement itself, according to the city, didn't even address or apply to that area. Now, we submit that the agreement does apply and does relate to that area where there's parking to the south and to the south of the Elks Lodge. But even if you were to believe, even if you were to look at Mr. Hirsch's argument, there is no way to hold Mr. Mo criminally liable for a violation of an economic development agreement that by definition wouldn't apply under Mr. Hirsch's theory to that area. You heard Mr. Hirsch say when he was summing up that the economic development agreement allows for parking, let me start over. You heard Mr. Hirsch say when he was summing up that the major issue here is whether the economic development agreement allows for parking outside of the site plan. Another way to say that is, does the economic development agreement allow for off-site parking? We have seen no less than 3 references to off-site parking in the economic development agreement itself. One at the Elks Lodge, one on the Zions International lot, and then the substitute lot or the substitute off-site parking that would be allowed if one of the other off-site areas did not pan out. Nothing in the economic development agreement, though, handcuffs someone to only park in these areas. The economic development agreement is a contract between the developer and the city. It does not say, thou shalt not park anywhere outside of the site, bus people in, you know, use surrounding neighborhoods for parking if that is acceptable and desirable to the patrons, to the business, to the city, to everyone involved. So what we have here is we've got a bolded violation that just does not apply. The site plan attached to the Second Amendment, it was said by Mr. Hirsch, was not prepared by the city. Well, neither was the third amended, or site plan attached to the Third Amendment. Now, but this is the basis on which Mr. Moe is being criminally, you know, cited, is based upon language in that site plan. We cannot ignore the site plan adopted and attached to the Second Amendment by the city on the notion that conveniently that Mr. Moe's engineer prepared that site plan and then focus only on a different site plan which was also prepared by Mr. Moe's engineer. And the notations on the third, or the site plan on the third development or Third Amendment to the development agreement, you can tell I'm getting tired, I'm getting a little tongue-tied, I apologize, folks, there's just so much going on that site plan. There's not as much room to put on those same tags as before. And yet it was obvious that zoning all around, and Mr. Hirsch did say in his statement, the zoning all around the hitching post was zoned for storage and parking, and that is obvious. There's a reference to the leased parking to the side, for instance. You saw in the old zoning code C3 that there's specific reference to automobile use. Automobiles are vehicles, vehicles are cars and trucks and things like that. You saw I accidentally, let's see, push something. I don't need that any longer though. I'm just going through my statements. Maybe we'll get it back on in just a second. You saw that the notion that Mr. Moe didn't submit an application for a non-conforming use or for a grandfathered use. Think about this. Okay, so the zoning code changes in 2014. How many existing businesses are there in the city of Apache Junction at that time? Do every single one of them flood the city of Apache Junction with these applications? No, that's not the point. When you change your zoning code, it is not a race to the city of Apache Junction and apply for grandfathered use. This is, and we can pull up the statute if I can turn the electronics back on, but the statute says only if you're seeking a license or a permit do you need to seek that certification. The grandfathered use is grandfathered use. This is constitutional. This is not City of Apache Junction code, guys. This is constitutional, and it's state statute as well, that the grandfathered use is there inherently. So if you're seeking a permit or a license from the city and you want to point out the grandfathered use, that's when you would need to apply. That is not what happened here. You heard Mr. Hirsch say that the city is basing its case on the fact that the economic development agreement only applies to the property that Mr. Moe owned at the time. That is what I made reference to a moment ago. If that's the case, you can't have it both ways. If the economic development agreement does not apply outside of that parcel that Mr. Moe owned at the time, then he can't be cited for violating the economic development agreement regarding a land outside of what he owned at that time. Okay. Mr. Moe, you heard testimony from multiple people that Mr. Moe actually did have a lease in 2015 for the parcel at issue, that the city has a copy of that lease, and of course he was here and did testify as to that. Now, getting back to what it is that the only language in the economic development agreement, okay, that was cited to, and listen as I quickly read this, as this is the whole basis of the criminal violation, okay? Developer shall build the project and improve the property in accordance with the site plan set forth in Exhibit B, which includes, among other things, a bull riding arena with events occurring only on Thursdays and Saturdays from 8 p.m. to 10 p.m. I read that last part that was irrelevant just so you didn't, so you knew I didn't leave anything out. This is what they're citing that Mo did wrong criminally. He said it's either that he did not build the project or did not improve the property in accordance with the site plan. Did Mo build the project in accordance with the site plan? Yes. Did he improve the property in accordance with the site plan? Yes. You've heard no testimony otherwise. This is the only basis and only reference. It doesn't say what Mr. Kirsch said it said. And we went through this so quickly, it sounded like that it was saying that you could only park in accordance with the site plan. This is the language. And if you're going to cite to someone criminally, you have to be very specific about what that language is. Mr. Mo did do those things, okay? Now, we know, because we've gone through it many, many times, that the use of the outdoor bull riding arena is conditioned upon the shared parking agreements for overflow off-site parking on vacant property to the south or across Lost Dutchman Boulevard. And then there's this reference to comparable off-site parking arrangements could be secured otherwise. Mr. Ralph Pugh, former lawyer, did not say that they were abandoning the Elks Lodge parking. They just said at this time they're not pursuing it. Now, at the same time that the Elks Lodge parking was referenced specifically, expressly, in the Second Amendment, well, at that same time, the site plan was not showing Elks Lodge as parking. So, had Mr. Mo worked a deal with Elks Lodge, suddenly would it be illegal for him to have parked there because it wasn't showing up on the site plan? No, absolutely not. In other words, it was not the intention. When you look at contracts, and this is a contract, you look at the intent of the parties. It was not the intention to show all possible parking spaces on the site plan. Else, it would make the entire reference to Elks Lodge complete nullity, and you can't interpret contracts that way. The courts say, no, you're not supposed to interpret contracts as if language is superfluous or irrelevant. No, you're supposed to try to give meaning to every word in the contract. Elks Lodge would be completely meaningless if the site plan, which doesn't reference Elks Lodge, was the holy, canonized version of where the parking could be. Now, just I want to close with a quick analogy. So maybe this is not the best analogy, but I'm tired. So analogy is, and I think I've provided this before, building a house. The approval of the house plans show what the builder needs to do to build the house. The approval of the plans do not show whether the homeowner can park on the street in front of their house or across the street in front of their neighbor's house, or even if they could park on the side of the home. And that is perfectly fine because that is not the point. And here the site plan had a specific purpose. It was not a prohibition of you cannot park anywhere else other than what is specifically put on the site plan. Why were certain parking spaces outlined on the site plan? I'll tell you why. ADA. Okay, those are the ADA areas. Okay, but it was never the intention that all parking spots would be outlined on the site plan. It was just, and if you look at it, that's where the wheelchair accessible parking spots are. And that is, that's what the city wanted to do. So the intent of the parties was to not necessarily show all the parking spots that would be available for the hitching post on the site plan. That is obvious. And in situations like this, when dealing with a criminal violation against someone, as opposed to, for instance, having the city decide this matter in Superior Court through a declaratory judgment action, asking the court to interpret the contract, which is clearly up for discussion after many hours and up to many interpretations. There are multiple routes to go here. A criminal violation or a criminal citation that would shut down Mr. Mo's business is not the way to go. And that's what I would kindly submit to you and assertively submit to you, because it feels and it is right. Thank you.
Board members, any questions? All right.
You're tired, it's okay.
Yes, I am.
Does anybody else have any questions before I?
Go ahead, Braden.
Okay, thank you.
Try to keep it short.
I'll try. I know the computer is not working right now, and if we could get that back up, that would be great. You mentioned showing the grandfather statute. Can you hold that up for us, please, and provide us your interpretation of that?
Right.
Thank you, Matt.
Okay. I don't know if this is going to work, but I'm going to try. Okay. Oh, it's still firing up? Okay.
That's fine.
I don't know if this is terribly unconventional, but I do have it up on my laptop. If I could bring you my laptop and you could.
No, well, I think we need to see it on the screen.
That's fine. While that's happening, I can ask my second question. I'm sorry? Okay. I kept hearing reference to, and this was in the public hearings as well as I believe you mentioned it, this supposed lease that occurred in 2015 that the city is saying that they don't have. Do you have it?
I do have it, yes. And I would have imagined it would have been in all of your materials that you had received.
I don't believe it's in the city's packet, and if it is, then it's buried under exhibit after exhibit somewhere. Is it
Given
in
the fact
this
that there was
packet?
300 some odd pages in that packet, I would have imagined it would be in there, but
is that, I mean, is that, I'm sorry, and I don't mean to be rude about this, but isn't that the burden upon you to provide that? I mean, you also provided a packet with,
sure,
many pages, and I would think that if that at least is a,
no,
that's a pretty substantial document, and I would think that you would also want us to see that lease agreement.
Well, and my point to that is, yes, I agree with that, but it's my understanding that emails to a city official are of public record, so that would be something that could be pulled up by a public record request.
Absolutely.
So has to be some form of acknowledgement, I would imagine, that even if Mr. Esquivias or whomever that email was sent to did not respond saying, hey, I received your email, that there's some way to track that was received, that was put into an inbox, and at that point in time, then that would be upon the city to do what they need to do. So in knowing that that's out there, and if that's something that you have or the city has, then yes, I do feel that is relevant as a piece of evidence for the board to see, to look at what was in the 2015 lease agreement.
Right. Excellent.
We don't have it.
They have it.
That's not, okay. Folks, I am so sorry that I pushed the power button with my knee.
We're going to take a 5-minute break while we get the system rebooted.
Thank you.
2-minute break.
2-minute break.
Matt is really good, so take a quick break, folks. Oh, yeah.
And then they can do their last one, and then that'll be sufficient.
Yeah.
Because otherwise we're gonna be here for, you
Yeah.
guys saw.
Burden is upon the applicant to turbine.
Little dots diving in the water.
Yeah.
Basically,
Sure.
what's it?
This is one of the reasons
That's,
Yep. You got a desktop?
Thank you, Matt.
You bet.
Without you, this whole place would fall apart.
Yeah, but it wouldn't have my video all over the world either.
And I hope that's on record for Mr. Bravo to hear.
I think we need a bigger hammer. 36-inch pipe wrench. Oh, man, now I did it.
I promise, these are the only two questions I have. We can't see that right now.
We can't. Okay. Don't bring it up quickly. Wouldn't be a good idea.
is there any reason that it's had to start at 7?
Why not at 6?
If the hour would make a difference.
Sure, would we be an hour ahead right now?
That's right.
So at 6, it'd be 9:39.
Park and Rec starts at 6.
Yeah. And I always barely make it from
Yeah,
work.
because Parks and Rec is a
Listen, we have intense political debates there, all right? About where the dog park should go.
Why not a cat park? Can we discuss that?
Because cats wouldn't stay in the boundaries.
That's segregation. How do you know?
Amen to that. I am 100% against cats. I'm segregist.
Us cat dads need a place to take our cats.
You could
Okay.
bring yours on a leash and let it go, and if it runs away, you know, it is what it is.
Guess I can just pull these up.
Your cats get out?
No, they stand up.
Oh, they do?
They try to get out. But they go outside and go, oh my God, what did you know that?
See, my wife.
Turn my book in.
Yeah, I
is not
came unplugged.
I don't mind cats so much, but
little notes.
they just. I
Well,
don't
he
like
did.
with all dogs.
He turned it
I don't
off.
know what you grew up with. But my
Yeah,
That's not
I think you're gonna stop coming out here.
loves cats. We've got my daughters all like, we need a cat. We need a cat.
Coming on home.
Oh, wow. Congratulations. So what, you're going from Winkleman? Is it Winkleman you're in right now? Where are you right now?
They have piles of gravel.
Oh, you were in Phoenix. Okay, I thought you were like rural
Oh,
area.
yeah.
You had already downloaded, right?
Yes, that
Okay.
is a.
What I do is I go to government.
Pleasant stuff.
That's right.
No, I did not.
When
didn't
were you
download it.
a city attorney in Duncan?
We found next door on the car.
So
Okay.
Little bitty kittens
Okay.
without their eyes open.
Yeah.
Do you know Danny Ortega?
Which one's yours, right there?
Yeah, that's
Well,
what.
you know, have they been weaned? No. Well, we don't have a nurse in.
Jack, there you go.
Well, it was a long way to the lake and I didn't have a brick in a bag,
on the city.
so we raised them.
Yeah,
People like that story.
somebody abandoned
So now go
3
to
puppies
government.
right in front of our shop.
What?
Yeah, like
City
newborn
Yeah.
puppies. I don't know, little.
Agendas and minutes. There you go.
I used to have
You know your
I used to
way.
have a link up there.
They were all clean.
Yeah, you gotta click on that, and then you gotta go to the meeting, and
But not a rat dog.
Is that today? No, that's next week. So we are at Board of Adjustment. There.
It's funny, none of the neighbors were here. Were any of the neighbors here?
2 minutes are up, Matt.
I think they figured it was a hostel.
Somebody told me to sit on it.
Oh, and you know what? It's funny. I even saw that when you stood up, and I was going to say something on the way back in.
Would have had a spare one for you all along.
I know. That's what. I grabbed that pen, I kept trying, I was like, oh, no, no.
You got my VFW.
You all can't say you're tired. I'm the one that's been on the road all day.
So, are we there?
Yeah. For noise.
Are we there?
Let's go down to page 19 in the zoning code. Is that, is this okay? I'm jumping into the non-conforming use
Yeah,
question.
we are back in session.
Thank you.
Okay, so in the non-conforming use section, which is section 1-2-5, what I was referring to, and of course there's all this good language about the constitutionality and the fact that legally non-conforming uses need to be observed and continued after adoption of zoning changes.
I'm sorry, is this A.R.S.?
No, this is in the Apache Junction
Thank you.
Zoning code. There are separate A.R.S. statutes. And the certificate referenced, the certificate of legal nonconformity. Number one, no permit or license shall be issued for a nonconforming use or structure until a certificate of legal nonconformity has been issued by the zoning administrator. Okay, what about existing permits or existing licenses? This is why you don't see a flood of businesses needing to come into the city whenever it changes its zoning code. So you have thousands of applications for this certificate of legal nonconformity. This is talking about new permits, new licenses, because they are newly issued by the City of Apache Junction. Was Mr. Moe required to apply for that certificate of legal nonconformity? No, he wasn't. This is a small point, but this is a relevant point to the issue of the grandfathered rights, which I didn't spend much time on, but I agree is relevant and maybe more relevant for another hearing with a different type of violation at issue. I keep coming back to the fact that the violation at issue here is the criminal violation against Mr. Moe, saying he did not follow the economic development agreement, that the parking was prohibited by the economic development agreement, which is just not the case. There's no language that does prohibit that parking. And then, let's see, then the other question.
The other question was in regards to the lease and
Oh, yes,
where is it and why have we not seen it ever?
What I'd like to know is what does this lease say? What does it supposedly say?
I can pull up the lease on my computer. Mr. Moe's
Can you then show it over the camera?
Oh, that'd be great if there's not a glare, but Mr. Moe will be back in the next probably 60 seconds with the hard copy of the lease as well, and then we can just use the, let's see if we can just use the Elmo. That's what this is called, right? The overhead projector is called an Elmo. This is not the most ideal way.
10235A.
Sorry. Here, why don't you help me here? Oh, yes, thank you. Yeah, Devon is pointing out that all the different various lots are being referenced, including the lot, which is the
Thank you.
0025001C, which has been referred to many times this evening.
And 001C, just for clarification's sake, is what is being considered the parking and storage lot.
Yes.
Thank you.
I believe that's, I'm 99% sure of that at this point. As I get more tired, I might be 98.
And that's a 10-year lease beginning December 1st of 2014.
Right.
No, it says 14.
It says 14. But it was dated
Dated 15.
15.
15 years.
So,
Well, that's
sorry, we used the phone instead. Now that's,
okay. So while I understand that this is put on paper, I mean, I don't believe this was done, but who is to say that somebody did not just run to some place and go type this up on a piece of white paper and throw it on here?
Wait, whoa, 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 whoa.
okay.
So where is the, again, this is where I go back to where it was sent through email and received by a city employee, that type of documentation, because that is public record. So that is what I'm looking to see, is the public record of where this lease agreement is, because this could have been on a computer and gone back and found. So there needs to, I'm looking for an email or affirmation that a city employee, be it Mr. Esquivius, be it another planner, received this email.
Okay, here it is. Okay, so this is on the October 9, 2017. Again, I'm sorry, it's on a smartphone, but is there any way to?
I think this is a lease agreement that was attached to this email from Rudy.
Here's the email. This is Rudy. You don't see his last name. Is there any way to make that?
You have to,
It's okay.
I don't think we need to worry about
Yeah,
that.
I think we got it.
okay.
You're good.
Okay, so, I'll just scroll slowly so we can all read this.
Well, what I see that lease doing is he's leasing the property, but it's just a lease to lease the property. It doesn't give any specific reason, planned use. He's just leasing the property.
And is that also, that, if that email was sent in 2017, then that's when he's leasing the property to himself then, is that?
This is the 2017 reference is when Rudy found this lease in the city records. He's saying, is this what you're asking about, et cetera, right?
So
Can you go back to the original?
Lease?
Or, yeah, the lease on there.
I don't think this case lives or dies on this point, but.
No, and that's, but, yeah, I mean, they've also, this has been brought up, so.
Okay,
Okay.
Okay.
Braden, any further questions?
I can testify as a lawyer that a lease like this is, it would be considered a general lease for all applicable purposes. There is no carve-out in a lease. If you lease me your commercial property, I get to use that commercial property without exception unless the lease says that there is an exception.
Well, it would be within the coding requirements of the city when you lease the property. You can't just run amok with it.
What I'm saying is that a lease has no exceptions in the actual private agreement between landlord and tenant unless it's spelled out in the lease.
Okay.
Mr.
Braden,
Chairman,
anything else?
could we ask the applicant to give a copy of both the lease and the email or to the,
Sure.
into
Yes,
the record?
absolutely.
I know you don't have a copy of the email, but if we could have that submitted at some point.
Okay. Would you do that, please? Thank you.
Yes. Submit this right now, correct? Yes. You mind if I approach?
No, just submit it.
Oh, just submit it, okay.
Yeah, just with Rudy,
All
whoever's
right.
handling the paper. I just want to make sure we have a clear record.
Okay.
Thank you.
Very good.
And if you could then submit, you don't have it now, but you could at some point submit a copy of the email.
Absolutely.
That was referenced to the staff as well.
Absolutely.
And can I add a clarification to the, or an addition to that, and the original email from 2014, 15, whenever?
We'll submit everything we have on the, on this email chain,
Well,
yes.
all I want is the things that have been admitted into the record tonight. So those two documents have been in the record. So everything else would be superfluous and we'd be having we'd have everything open later, so.
I guess I would disagree, and please correct me, but at the point, that email was back in 2017 with Mr. Skevius acknowledging that at some point, the city received it. So would the original email from 2014 or 15 not be a part of what you're asking for? Because they had to have initially received it for him to say in 2017 he received it.
I mean, that's that's an inference you could possibly make. That's not my role. My role is just to make sure the record's clear, and that we had two documents referred to. I just want to make sure they were in the record. And so if there's other documents out there, if they get into the record, great, but tonight we don't have them. So the two documents that we do have, I'd like just make sure there's a copy of those in the record.
Okay, thank you.
Walker? You had a
That's
couple
all I've got.
Huh?
Okay.
Good?
Yep.
Yeah. Judy?
I'm good.
Okay, sir.
Thank you.
Larry, would you like some rebuttal? Your opportunity.
Is going to handle the rebuttal for now, to start.
Chair, I'd like to do that. However, I'd like to ask Rudy if he would speak on the lease agreement fairly quickly, and then I'll do some comments so we can wrap up.
Okay.
Thank you, Mr. Chairman, members of the board, ladies and gentlemen. First of all, I'd like to thank Mo and Tina for assigning so much power to me that I can tell them to buy properties, combine properties, resplit properties, do this, do that, do bull riding.
Okay.
If I could only convince my wife that I have so much power, this would be a wonderful world. Mr. Chairman.
Mr. Eskevius.
Here we go. Okay, so there were two leases in question here. The first one is from Zion to Mr. Mohudin, and the signature is impossible to read, but basically this is Mo's signature, and this is a signature by a gentleman named Jim Kunkel, who was the property manager of the Zion International property back when Mo did his second amendment to the development. This, as you have already seen, is the previous parcel map. Now, if we look at this agreement, it says, provide overflow parking for the leasee indicated above. The vacant lot directly west of the parking safe storage lot. Okay, so this was the parking safe where that RV boat storage thing was, west of the parking safe storage lot. East, adjacent to Highway 88, which is right here, and to the south, adjacent to the Hitching Post Pub and Dashin Mini Mart, parcel 12503. If you take this lease at its face value, the only thing Mo leased was this little bitty triangle. Now, of course, that's ridiculous. Mo didn't just lease this little bitty triangle. There's a fence that basically runs right about here and that runs across here, which the fenced-in area, I believe, was created sometime after the hitching post got up and running. And obviously, it was meant to apparently park people who couldn't find enough parking spaces on this property. So it was always understood, even though this document very specifically says parcel number 3 only, it was always understood that this parking area really included parts of number 3, parts of 10E, and parts of 1C as delineated by an existing fence. Now, after Mr. Mohudin purchased the surrounding properties, of course, the lease with Zion International, between him and Zion International, didn't really make sense anymore. So when Mo was in the process of either applying for his first or his second CUP, I forget which one it was, one of the details we tried to wrap up was this outstanding or invalid lease between him and Zion. And Mo came to the counter, what should we do? I said, Mo, just lease the property back to yourself. You own it now. Lease it back to yourself. And that's what this other document that this gentleman just presented. I helped Mo, and I said, hey, Mo, the old document only shows number 3. Your new document should reflect, 3, part of 1E, part of 1C, and we're talking about the same fenced-in area. And he says, yes. And we had that discussion over the counter. We're still talking about the same fenced-in area, but in the more recent lease, from Mo to Mo, it was better described as pieces of all 3 parcels. Okay, and I believe, and yes, we do have a copy of that lease. We've never denied having a copy of that lease. I think it's probably buried somewhere in the one of the CUP files, because the acquisition of the surrounding properties and then the subsequent combination, and by the way, Mo acquired the properties in July 2014. This is subject to a special warranty deed from his title company. So subsequent to his acquisition of those properties and for the purpose of putting everything under one single CUP once and for all, including Mo's desire to have an extension of premises, to have a wedding venue, to have cornhole, to have fire pits, to have outside seating areas, in anticipation of that, and after Mo had acquired all of these parcels, Mo did a lot combo in 2017 where he combined all of his properties into one single tax parcel. Okay, this map was recorded December 7th, 2017. And then on December 19th, 2017, 2 days later, Mo recorded a deed where he combined all of the parcels according to his lot combo survey map. And then, about a week after that, subject to a series of deeds recorded December 21, 2017, Mo resplit his combined parcel back into 3 parcels. And this is the most recent property configuration. The one parcel includes the old hitching post. It includes the bull riding area. It includes the so-called former leased parking area. It includes the old Park and Save RV storage lot. The house was separated out onto its own parcel, and this other storage business or businesses that happened to the south of the hitching post were made their own parcel. So that enabled Mo to proceed with a CUP for this, where we were going to combine everything. What do you want to do, Mo? You want to expand? You want to offer all these other things? You want to have parking on the property? Let's get it all wrapped up into one CUP once and for all. He proceeded in that direction. He got his CUP approved, and then he didn't want to comply with any conditions, and the CUP was revoked. So he got everything he wanted, except for the conditions that he didn't want to meet, and then it got revoked. So that is the history of the 2 leases and what's happened on the parcel, the reconfiguration.
Any questions for Rudy?
Just one. In the merging of the properties to the split of the properties that happened over a week's period of time, did the zoning change on those properties?
No.
So it was at that point in time, this is 2017, so it was still B2?
No, B1.
B1.
Everything is zoned B1.
Everything is zoned B1?
Yes.
And it was zoned B1 prior to the merger of 1 to 1 lot?
The combo done in 2017, let me back up a little bit. The city's current zoning ordinance, like Larry explained a little bit ago, became effective in June of 2014. Okay, that's basically where all of most property, what used to be CB2, what used to be C3, is now all called B1.
Right.
Okay, that happened in 2014. So when the land combo was done in 2017, the whole thing was zone B1. And then when this is the combo. And then when it got resplit again a couple of weeks after that, it's still all B1.
But from the original parcels, it was C, and then he merged everything to one. In 2017, it became B1 and remained B1 upon the split back to 3.
Yeah.
Okay, that's
Correct.
just
Yes.
making sure I understand.
Okay. Anybody else have a question? Thank you, Rudy.
Thank you.
Thank you, Rudy.
How much time do I have? About 2 hours?
You have 34 seconds.
Well, I don't know if I can do it that fast. Joel Stern, once again, city attorney. I do want to point out one thing. Well, we'll start with a bunch of things, but go to Exhibit 3, and Mr. Brower forgot to read part of the paragraph that talks about development agreements, about halfway down. He went about halfway and then he stopped. And then where I'm picking up is development agreements must also benefit the local jurisdiction with sufficient legal consideration. The key phrase here, or the key sentence, the city may include conditions, mitigation measures that must be met to assure that a project at a specific location does not have unacceptable impacts on neighboring properties or community infrastructure. So that's another reason a site plan is required, so that the city can measure, when someone has a project, how it's going to affect the surrounding neighborhood. Now, one thing we didn't include, we probably should have in the beginning. However, if you take a look at Exhibit 5, last page, actually not the last page, I'm sorry, the last page of the letter, page 2, parking. This is a letter from Mr. Kirch to Mr. Mohadeen. This is the first time that the city told him this parking is illegal. Look at the date of that letter, November 16th, 2016. Under our zoning code, he had 30 days to appeal that. He did not do that within 30 days. In fact, you fast forward it, it's well over a year that he appealed. So actually, this case, procedurally, he messed up the deadline to appeal. So I would submit that also. Going to exhibit number 17, that is the site plan that the business is operating under. We've seen this, I don't know, 5 times already. I'm not going to put it up back on the screen, but in your packet, there's a yellow line that shows that was his property. That's what he owned. That's the site plan. This is what governs everything right now. And if you look to the east, do we want to talk about north, south, east, west? Well, everybody took a geography class. So east of the bull riding ring is an empty lot. And yes, that's zoned for storage of RVs and boats. Okay. That's if you have a business there. You can use that for that purpose. You cannot use that to park vehicles from a different business. You cannot do that. That is the zoning administrator's interpretation. That is a correct interpretation. Let's go to some of the comments, and then we'll wrap up. This is not a tail light case where you get cited for a tail light. This is a zoning case. This is not tonight, if you hold for the city, you don't criminally convict Mr. Mohadeen. That's not what the effect would be. That's not what it would be at all. Yes, there are pending parking violations in misdemeanor court. That's true. And those are stayed until you make your decision. and the appellate period's over. And that's for a judge to decide whether there's a violation. But you're not deciding that tonight. You're deciding whether there's a zoning violation. When we do normal development, a site plan is required. So even for non-development agreements, a site plan is required. When Fry's came in, they had to do a site plan. Now, they don't have a site plan that says, well, we can park anywhere else. We can park across Idaho Road or Old West Highway. They don't do that. Everything's on site. That's the whole point of a site plan. Okay, going to yes, there was a lot configuration. That was done in 2017. That does not take the place of a site plan. That has to be considered by the city council, the configuration, so that they can judge whether that effect, where he wants to expand his operations, is going to affect the surrounding neighborhood. The city has a right to do that under city code. The A.R.S. governing development agreements say that the property has to be identified, and that's why we have a site plan requirement. The city does not want to shut Mr. Moadine down. We have helped Mr. Moadine. Rudy and Larry have. I have. I suggested after he lost the first CUP in 2013, I suggested there's this great, excellent attorney, the best attorney in the state. And I did tell him that, and that's Mr. Pugh. So I suggested he go to Mr. Pugh. We bent over backwards for Mr. Moadine. The city council did in 2009 when they waived the almost $47,000 in development fees. Does the city do that for other businesses? No, we don't. There's a lot of issues that were related to that. There was a former council member involved. There was a recall right before that. So it was a very politically difficult time. However, the city did waive it. The city had to pay back that money, meaning they take it out of their general fund and put it back into the development fee fund. It takes a lot of sales tax revenue to make up for $47,000. So we like the city likes a hitching post, loves it. However, he's got to follow the rules, just like everybody else does. The city doesn't discriminate. We've been accused of that. There was a federal lawsuit involved, and Mr. Moadine did dismiss that lawsuit. And there were 3 conditions. Dismiss with prejudice, meaning he can't bring it back. Also, that he enter into a Fourth Amendment development agreement in good faith with the city. And also, that he follow the rules regarding noise, a wall, and I believe lighting, and a few other things. So I think one of the board members asked, well, what was the process? And I think it was Mr. Walde, where we were on the Fourth Amendment. We did attempt to do that, but the negotiations failed. So that's why we're here today, because we thought if the Fourth Amendment was entered with the protections for the neighbors, that the Fourth Amendment would take care of this case, and then this case would have been dismissed. We would ask that you hold in favor and uphold the Development Service Director's opinion that this is a violation of the Development Agreement Code. Thank you very much.
Any questions? Okay. Mr. Warden, the appellate have one more chance to come back.
The applicant does have the final word.
You did say final word.
Well, there's lots of words left.
Type.
I want to just kind of come full circle back to that this is, look, this is a hearing in which the allegation is that Mr. Moe has broken the law. This is a hearing that will detrimentally affect Mr. Moe financially and in a very significant way. This is a hearing that has direct implications on pending criminal proceedings. Let's not pretend it isn't. When you say that someone has violated the law, you have to apply certain due process standards to it. If the law is not clear, and by the way, what law has been violated? I implore you, ask your special counsel this. Is the law clear on this point, that there is even a violation here available for a contract interpretation of a development agreement that is so muddied that it took, however many hours tonight, and at best we're leaving here with it being clear as mud. Most of what is being discussed about confidential settlement negotiations, confidential settlement agreements, failures of this or failures of that, all boils down to irrelevant but important, because the main thing on trial, and it shouldn't be, is the development agreement itself. The development agreement itself is on trial. What would be the preference here, not of Mr. Moe, but would be the preference is to just get rid of the development agreement, require a $100,000 wall to be built, require all these onerous issues that maybe the business would have to shut down in 12 months, require a process by which neighbors get a chance to now sue the city or raise other issues. This is not what we're here for today, though. We're here to just decide the simple issue: did Mr. Moe violate the law by violating specific and clear language in the development agreement? We're at the end of the hearing today. Have you yet heard where in the development agreement it is specific and clear that prohibits all parking on that property? Do you hear anything in the development agreement that's specific and clear that would prohibit parking even on the one parcel that we keep on talking about to the south of the Elks Lodge? No, you have not. And as a result, there is no criminal or there's no allegation that Mr. Moe has broken the law that will hold up in court. And so we ask you, please take that into account and let's go at this a different way. And I appreciate that, and appreciate all of your time. And thank you very much.
Thank you. Okay, board. This matter is now closed to the public. It's up to the board to discuss. And I'll start down there with you, Judy.
You get to go first.
Okay. As I've gone through this packet, I've seen a lot of necessarily violations that have come through the past years. Things that were either have not been corrected, and so I'm going to have to vote no.
Okay, we haven't had a motion yet.
Okay.
But you that's
Yeah.
fine to give your opinion. So, Jesse, would you like to speak on?
Yeah, from my perspective, the economic development agreement was entered into. Everybody understood what the footprint of that was. I have been to the hitching post. I don't go a lot, but I do go. And from my personal perspective, the parking in the back that is at issue is a pretty good location. However, since you have basically what you're doing is expanding the footprint of the economic development agreement. The city does have and should exercise its right to determine how that parking lot is configured and how it's built. And that's kind of the issue here in my mind. And I feel that that the parking issue needs to be addressed in a CUP or amendment number 4 before parking goes on there. That's basically a non-permitted activity on that property.
Luciano, let's start with you. You got anything you want to say?
No comments at this time.
Okay, Braden?
Surprisingly, no comments.
Wow. Walker?
I mean, there's obviously a lot of passionate feelings, I think, both ways, and we've heard, definitely from Mo's supporters about why he feels like he should be able to park in the, in the disputed area. The burden of a neighborhood, though, is to interact with all those around them as well. And I also feel for the neighbors that purchased homes in that area long before the hitching post came around. But I also understand that, you can't stop growth. I'm saddened that we could have not come to an agreement long before we came to this council. And I think that we as a board and as a city have given Mo many opportunities to come to the negotiating table, understanding that it's going to require some pain, maybe financially, to work something out in possibly a 4th agreement or a CUP. And that's, I think, all I have to say at this time.
Thank you. It's a shame we're here tonight. It's interesting that we have this kind of conflict when both parties are working in the same direction. Apache Junction would like to grow. It would like to grow with families. It would like to have events where families can have a good time. Mo has a location where he's trying to do that. The unfortunate thing is there's a history of lack of cooperation. And that's been answered by the city by some pretty onerous conditions they put on one CUP. I remember when that came out. It was like, holy cow, there's no way he's going to be able to do this. So we get to this impasse, and it ends up in front of a board made of 7 members of the community who are lay people and who have had no legal training, and it's up to us to try to decide the fate here. Again, I'm really sorry it is even here. It should not have come to this board. It should have been worked out by reasonable adults previously. But we're here and we have to decide. So there's going to be a winner and a loser here tonight. And I'm sorry that has to be that way. Personally, I find the site plan, it describes what has to happen there, but I don't see the restrictions beyond the site. I don't see where you can't do this or you can't do that. You can do these things and you have to do these things on the site. Okay, those have been more or less done. I find it hard to believe that if it was me and I owned that property and there was a parking lot 3 blocks down the road, that customers chose to just go park in and walk to my place of business, that would be a problem. However, I understand that for lack of a better term, the east parking lot where the RV and boat storage is not zoned for parking at this time. And that's a shame, because it seems this could have been very easily worked out. We wouldn't be here tonight. Mo would have parking. Things would be going on at the hitching post, and it would be a happy community, except for some neighbors who don't like the noise. And unfortunately, they placed a bet when they bought property next to a commercial area that was quiet. Well, you can't guarantee that a commercial area is going to stay quiet. There's no way that you can guarantee that. You placed a bet when you bought those properties. So, I don't want to see the business shut down. I hope that doesn't happen no matter what our vote is tonight. And again, it's a shame we're here, but we are, and we have to take a vote. So at this time, I would entertain a motion.
Can we, Mr. Chairman?
Yes.
Can we review what the motions are and
You bet.
how they affect whatever it is we're deciding at this point?
Yep. All I have to do is find it.
It's under staff memo.
Okay.
It's page 6 of the staff memo.
Early in this.
Did you want that on the screen, Mr. Chair? For the audience purpose?
Would you like it on screen? Yeah, that'd be great. Okay, it's on.
Just as a matter of clarity, there's also recommended motions under section 3 of the applicants.
Yes, there's a motion both to deny and there's a motion to accept the appeal.
Thank you.
And I would take a motion in either direction.
In your motion, we do need to have the findings too, and there's findings in both of those
Correct,
sections as well.
correct.
And if you need to review, the findings of fact are given to you as helpful. They're not necessarily, I mean, they may not be your finding of fact. If
Correct.
you have something else that you might want to put, that's fine as well.
Mr. Chair, sorry, just as a clarification.
Yep.
So the one in the city's packets, that's voting in favor of the,
I would deny the appeal.
That is voting in
I would
favor
deny
of
the
the
appeal.
city.
Okay,
Correct.
sorry.
Be voting to deny the appeal.
Just want to make sure. we're
Yep,
clear.
yep.
I didn't understand what you got said.
The one in the packet
Yeah.
is saying that the zoning administrator is correct in their interpretation. The one in this packet is stating that they are not correct, and we are siding with the business. A denial means we side with the city. An approval means we side with the applicant.
Okay, I'm more clear now.
Well, you don't have to necessarily agree with the findings of fact to make the motion. You can make your own findings of fact.
There will be some findings of fact.
There will need to be findings of fact, but they would necessarily need to be the ones that the city gave us.
Correct. Or the applicant.
But we do have to have a reason for our decision.
Correct.
But before we can decide, we need a motion. Or we can just go home.
Mr. Chair?
Yes.
I'm would like to recommend a motion. I'll just read this one?
Yeah.
Read the one? Okay.
Well, let me just say, it. The recommended motion is the recommended motion. So if that's the one, if that is your motion, then that's what you would read, and same thing with the findings of fact.
Okay, hold on one second.
So if that's your motion, then that's your motion. You would incorporate that as your motion, but you can make any motion you see fit.
Upon citations of fact on either side, are other board members allowed to add? Because there's several, I mean, there's the recommended findings of fact, and then of course we can add our own. Can we add, if he's going to make a motion, can another board member add additional findings?
You would have to
Modify.
I'm not the world's best parliamentarian. So you'll have
Modify
to-
the
you'll have to
modify
modify the motion.
Understood. Thank you. Is somebody keeping track of?
Yes.
It's going to get confusing.
Well, it is.
Mr. Chairman, I would like to propose a motion that pursuant to AJCC Volume 2, Section 1-16-4C1, I move that the case BA 1-18, an appeal to the Board of Adjustment and Appeals by Mahmoud Mahadeen, the property owner, represented by Aaron Ludwig of Ludwig Law Offices Ltd., appealing notices of violation dated October 31st, 2018, code case number COD 2018-00723, and November 7th, 2018, code case COD 2018-00751, an appeal of the zoning administrator's decision that parking is allowed by the Third Amendment to the Economic Development Agreement between the City of Apache Junction and Mahmoud Mayadeen be denied with the following findings of fact. The applicant has not presented evidence nor met the burden of proof to demonstrate that the zoning administrator erred in his interpretation of the zoning code. I don't know that I want to go through all the rest of these. I think that's enough, isn't it?
That would,
It's up to you.
I think that would be sufficient. Do I have a second?
I'll second it.
Motion's been made and seconded. Is there any more discussion?
Yes.
Please do so.
Give me a second here, please. The findings of fact that stated by Board Member Gage state that the applicant has not presented enough evidence nor met the burden of proof to demonstrate that the zoning administrator erred in his interpretation of the zoning code. I disagree with that per the C3 zoning, which at the time was in effect and does, to my interpretation of 1-16-5-1, under statement of legislative intent, allow that parking. I also believe that per the compliance agreement, while yes, a CUP did go into effect, sets a very dangerous precedent because in the compliance agreement, which was prior to the CUP being in effect, the city did acknowledge and agree to allow parking on the parcel, I don't even know what parcel it is at this point, even temporarily while going through the process for an economic development agreement or a CUP or to sell the property or whatever. These were separate parcels. When I look at the economic development agreements, the second or the third one, the property in question was not owned at the time by the hitching post or its owners. It was leased, and yes, it is not on the site plan, but a property that is not owned or not included should not be on the site plan. It was leased. Per the second economic development agreement, there is a statement in there that does allow off-site parking to be valid.
Okay.
That's everything right now.
Anybody else have a comment? Okay, at this time, I'm going to ask for a roll call. When you give your vote, along with the fact that we have done a finding of fact, you may also express any other opinion you have as to why you are voting the way you are.
Mr. Chair, I'm sorry, I'm tired too. I didn't hear a second. Did someone second that motion?
I second
Oh, okay,
that
I'm
motion.
sorry.
Judy, are we okay then?
Mr. Chair, I also have a question. So a yay or a yes, and this means that we're upholding the city's findings, and a nay means that we're in disagreement.
Correct. A yes vote means we're denying the appeal. A no vote means we are not denying the appeal.
Correct.
We're voting against the denial.
But only based off of finding of fact number 1, 2 through 8 do not matter because they were not stated in the motion.
Correct. Only fact number 1. However, if you wish to state why you personally are giving your vote, that's allowable, I believe, Mr. Warden?
Absolutely.
Okay. So we have a finding of fact, but you also are allowed to express your opinion. So Rudy, I think it's time for a roll.
Board Member Walde.
This is not, first of all, I hate going first. I always get called on first. This is not something that I enjoy doing. This is I think one of the dirty parts of politics and of serving on a city board. Mr. Mohadeen, I feel that there have been many violations by you and your business. In this case, I feel the city has tried to do its best to work with you, and at the same time, I feel the city has been unduly burdensome upon Mr. Modine and his business. As someone that operates a business in Apache Junction, working within all the zoning regulations and requirements can be overly tiresome and burdensome. In this narrow case, I'm going to side with Mr. Mohadeen, only on the fact that upon his acquisition of the property, I feel that it was then in his right to allow his patrons to park on that lot. With that being said, I still find many of the things that Mr. Mohadeen has done in provoking and bringing up many of the difficult things to the neighborhood as being overly burdensome on those neighbors that are around you. We are a community. And I would like to see us grow and continue to grow. And Mr. Mohadeen, I've visited your establishment, and I think it's wonderful. I think it's going to do great things for the city. In this one narrow case, I do agree with you, but I would say you're also walking a dangerous line to continue to push the city to these kinds of decisions and these kinds of boards. So with that, I will vote. No, I vote that Mr. Mohadeen, that the zoning administrator was incorrect in his findings.
Wait, okay, technically you're voting against the motion, which is to uphold or to deny the appeals. You're
Correct.
voting to deny the appeal.
No, he's voting,
I'm voting to allow the appeal, sorry. So that's why I'm trying to figure out what.
Well, that's not the motion.
he's voting no against the motion.
No, vote against the motion. The motion is to deny the appeal.
Okay, so I vote,
No.
He's voting in favor of the appeal.
I vote in favor of the appeal, so.
Correct.
Whatever
Well-
that be, yes or no.
The motion is to side with the city, so your vote would be no if you do not side with the city.
It's not a small issue. Saying if this motion fails, that doesn't mean that that the case is over. That means now we're gonna have to discuss where we go from there. So you're saying there's a motion right now to deny the appeal. So you're voting you're voting no, don't deny the appeal. You're voting against the motion, which is denying the appeal.
No.
I'm not clear on that.
Yes,
Yes, correct. Yes, we were saying the same thing, it's just that it's not an error, it has to be,
If this motion gets defeated, we need another motion.
correct, that's what I'm saying.
Okay,
All right, so you're voting to defeat this motion.
all right.
Yes, as a no vote, thank you. Just want to be clear.
Keep going, Rudy. Next.
Board Member Busin.
Well, after hear so many issues, and I remember to be the planning and zoning, we discussed this one here, and I voted no, because so many times the city went against people that want to do something good for the community, and I voted no against the city.
So that's a no?
No.
Okay. Board Member Bory.
Yes.
Chairman Shanebeck.
Oh, boy. I feel much like my associate here, Walter. This is really tough. Mo has made this a lot harder for himself than he would have to. I think what I've seen over the years is there seems to be a disconnect. Mo would work very hard for this community. He has in the past. He's been very generous with his efforts for the community. But there's a disconnect between the community and the city government. And I like to think here in Apache Junction, the city government is part of the community, not an enemy of the community. And that we need to work together as one in order to move this community forward. If we're gonna go hammer and tongs against each other, it's not gonna happen. I've been impressed with the city staff since I first arrived in this town 10 years ago, with their dedication to the city and their hard work and really concern to make the city right. It is a tough one, but with all this in mind, I don't find that the Economic Development Agreement specifically negated other parking. It suggested some other off-site parking. It suggested possibility of other off-site parking. There were steps that should have been taken to assure there was more off-site parking. But I'm going to vote no on this motion because I think it's out of proportion. I think there could be too much damage done for the violation in question. I don't think Mo ordered anybody to go park there. At the same time, I don't think he stopped anybody. But I don't see Mo out there with a flashlight waving people to go park over there. I think they chose to park there because there was empty land and a place to park and that was nearby. So I vote no.
Board Member Biggs.
I echo the sentiments of the community. There are people in the room from Tempe, Santan Valley, all over the place. There are Canadians, I'm sure, that come here and think Apache Junction is home. I interpret the C3 zoning at the time differently than the city. I believe that the fact that the city acknowledged a compliance agreement at some point in time, they were aware parking was occurring on that. I find issue with the fact that parking has been occurring on that lot since 2015, and in 2017 or 18, the wind changed and it became an issue. Those lots were on separate parcels. I agree that the Economic Development Agreement has jurisdiction over the lots that were owned at the time. It does not have jurisdiction over anything else. Somebody stated that the business owner should not be cited for someone not parking where they're not supposed to. I equally agree in that. I know there is parking on extraordinarily busy times that happen across from Highway 88. Is that the fault of the business owner? No. Is that the fault of the person who parked their car across Highway 88 and decides to run across a state highway? Yes, it is. I think that the city has a lot of events throughout the year. I can think of a few parades we have down Apache Trail and a couple events that we have at Prospector Park each year where parking is not enough. And is the city cited for those residents in the community or those visiting the community when they don't park in a compliance, in a spot that is there for the city? They're not. Look at our businesses down Apache Trail. Do every single one of them have shared parking agreements with the lot next door to park in that lot and they walk across to that lot? No, they don't. That's not how that's done. I don't believe the city has a shared agreement with every single business down Apache Trail to park down there when we have city events. I understand this is a heated discussion. I also do believe that the parking violations that are being held up in municipal court, the reason they're being held up is because of our case. When we determine that parking is not allowed there, they can then move forward with their motion and say that parking is not allowed there. If we don't say that, they, in my opinion, don't have a leg to stand on with that. So I also agree with 4 other board members that the zoning administrator's interpretation is not correct and will be voting no. 3 other members, I apologize.
Vice Chair Gage.
And again, I'll go back to my original statement that the economic development agreement laid out a footprint, and that's where the activities of the hitching post are supposed to be carried out within. And again, I have used the back parking lot. I think it's safer and it's better for the business. So I certainly hope that the city and the hitching post can get together and figure out how to make that a parking lot. But at the moment, that's not part of the EDA, and that's the line that I can't cross, so I have to vote yes for my motion.
So 2 positive votes on the motion to deny, 4 negative votes on the motion to deny, so the motion fails. Does not mean automatic approval, it means what, we take another motion?
Yeah, that would be the case. I would entertain another motion.
Mr. Chair, I move that pursuant of AJC Volume 2, Section 1-16-4, C1, I move that the case BA-1-18, an appeal to the Board of Adjustments and Appeals by Mahmoud Mahoudin, represented by Stephen Bauer of Brentwood Law Group, PLLC, appealing notices of violation dated October 31st, 2018, code case number COD 2018-00723, and November 7th, 2018, code case number COD 2018-00751, an appeal of the zoning administrator's decision that parking is not prohibited by the economic development agreement between the City of Apache Junction and Mahmoud Mahoudin, and the amendments thereto are granted, overruling the reversing the zoning administrator's decision with the following finding of facts. Wait a minute. That the second amendment to the economic development agreement does not prohibit parking on parcel 100-25-043C.
Mr. Chair?
I'm sorry, it seemed like it was a question. Did you have a question? Oh, I'm sorry.
Any discussion?
Mr. Chair?
Yes, I need a second.
Well, I would like to amend the motion.
Okay, you need to make a motion to amend the motion.
Oh, I'm getting too tired for this. I make a motion to amend the recommended motion as stated by Board Member Walde to include finding of fact number 2, the second amendment to the Economic Development Agreement does not prohibit parking on parcel 043C, as well as number 3, the third amendment to the Economic Development Agreement incorporates the parking requirements and allowances of the second amendment to the Economic Development Agreement. And number 4, that the third amendment to the Economic Development Agreement does not prohibit parking on parcel 043C. Parking is permitted in the parking area southeast of the rodeo arena.
You want to add number 5, as that would follow number 4 logically.
I will add number 5 off that recommendation, and number 5 is because parking is not prohibited on parcel 043C, Mahmoud Mohadeen did not violate the Economic Development Agreement.
Mr. Ward?
I believe that the person making the motion can then incorporate those motions
Okay.
if you want to amend his own motion.
And if I do not want to amend my own motion?
Then I believe it'd have to go to a vote. And again, I'm no parliamentarian, so I
You are
apologize.
correct. It's a friendly amendment at this time. You have the choice to accept it. If you accept it, we move forward. If you deny it, then it goes to a vote for
The original.
Yeah, sorry, I'm still going to deny it.
Okay.
then that needs to go to a vote.
So,
So we're voting on whether it's only finding of fact 2 or finding of fact 2 through 5.
Correct.
Correct.
how do we do this?
Vote for the
All
original
right.
motion.
Yeah.
Revised.
Let's take a vote for the original motion, and I need a second on the original motion.
We have to.
We
Have
have
to
to
have,
vote on
okay.
the amended motion.
All right, well, I need a second for the amended motion.
I second.
Okay. It's been moved and seconded. Roll call, Rudy.
Board Member Busin,
Yes.
Board Member Bory,
No.
Chairman Shanebeck,
Yes.
Vice Chair Gage,
Yes.
Board Member Walde,
No.
Board Member Biggs.
Yes.
So 4 in favor, 2 against, so the amended motion passes.
The amendments to the motion
The
passed.
amendments to the motion passes. Now we vote on the actual motion, which includes 2, 3, 4, and 5.
Correct. Is there any more discussion on that?
So I will say the reason why I'm not allowing the third economic agreement is because I believe this fundamentally comes down to whether parking is being prohibited or whether it is being allowed. And I think by giving those third amendments, it gives the ability for those to say that what is going on is currently okay. And like I said, with this finding, I do agree with Mr. Mohadeen, but I also would say that there is some validity to the city's argument, which is why I only allowed Second Amendment 2, or finding fact 2.
Mr. Chairman?
Yes?
For point of clarification, and this is where I think you might be getting confused, Walker, the only parking agreed to was in the second economic development agreement. There was no change in the parking to the third economic development agreement. It actually states that all other terms and provisions set forth in this agreement, the first amendment and the second amendment, not consistent with this third amendment, will remain in full force. So
Right,
you're
but-
disagreeing with the second amendment that you agree with, that parking is allowed.
Right, but I disagree with the parcel number. On that Second Amendment, it was a specific parcel number, and I think that they have gone beyond the bounds of the original things. Like I said, I think it's, since acquired the property, he now has the ability to park there, but like I said, we're gonna vote on the amended one anyway, so let's move along.
But
Do we have a second on the amended
we,
one?
we also have to go back to when the third economic development agreement was put in place. While I understand that he owns the property now, at the time of the third economic development agreement, he did not own that property.
Right, but
So-
at this point, we're arguing on semantics because your amended motion passed, so.
But,
We
my-
have to vote on your motion.
right, I understand that, but I'm just saying that you're,
I stand by what I said.
okay.
All right.
Mr. Chairman?
Yeah.
Just one more stab at this. Apparently, my footprint argument isn't working very well, so I'll try another one, that basically by buying additional property, we're going to allow him to change the terms of the economic development agreement. And I just don't think that's right.
We're not changing terms of the economic development agreement. We agree, based off of the second economic development agreement, that the parcel in question was not owned and therefore leased as off-site parking. At the time of the third economic development agreement, he did not own the parcel in question.
Correct.
So
He
the
didn't own
second
the-
economic development agreement stands that the parcel in question was leased as off-site parking, which is what the original motion says, which is why the economic development agreement does
No,
not
as-
prohibit
as-
parking on that
I believe I
property.
have the floor.
Yeah, all right. Okay. Jesse?
Thank you. As we saw Rudy demonstrate, the leased parcel is not the parcel in question. So.
Yep.
By accepting this, we're changing the terms of the economic development agreement with the city. And it's a bad precedent, in my opinion. So, anyway,
I
that's all I
agree.
have to say.
I don't understand how that parcel is not the parcel in question, but okay.
All right. We have a motion.
Mr. Chair, sorry, I'd like to add one thing, and that's,
Okay.
and this is why I'm gonna stand by my second finding, fact number 2, because while I agree with what you're saying, that I don't think that Second Amendment just limits, it does not prohibit parking on a different parcel. The economic agreement allows parking on that parcel, and he has since acquired property that has allowed him to park in a different spot. So that's why I'm gonna stick by the does not prohibit parking, but we're gonna go from there.
Okay. We have an amended motion on the floor. Has it been seconded?
Yes, but Boozine.
Okay. Roll call, Rudy.
Who
Yeah,
seconded
I'm
it,
sorry,
Mr.
sir.
Chairman?
Whoop, whoop.
I'm sorry, was there a question on the end?
No,
I believe I had a question, I'm sorry.
he was
No.
notifying that he had seconded.
I'm sorry, okay.
All right, back to roll call.
I'm sorry, Mr. Chairman, who was the second?
Luciano?
Okay. Chairman Shanebeck,
Yes.
Board Member Bory,
I think my brain's fried. No.
Board Member Busine,
Yes.
Board Member Biggs,
Yes.
Board Member Walde,
Yes.
Vice Chair Gage.
No.
4 in favor, 2 against, motion, the amended motion passes?
Yes.
All righty then. That gets us down to old business, which we don't have any. Gets us to new business, we don't have any. Because November 11th, 2019 is a federal holiday, we won't have a November meeting, therefore there will be a regular meeting on December 9th, 2019 at 7 p.m. in the City of Apache Junction City Council chambers located at 300 East Superstition Boulevard, if there are agenda items. I would like to thank you folks who were here tonight for your behavior. You did remarkably well. And with that, we stand adjourned.